Good morning, everyone.
Morning. Morning, Kia. Good morning, everyone. Wilana, how are you?
Yes, I'm good, thank you. How's my order? Okay, is it loud enough?
Yes, it is. It is.
Okay.
Thank you.
All right. I'm just always worried that it goes too softly somewhere.
Oh, no, that's just you. That's like you being soft, which is great.
Soft and cuddly.
Oh, thank you so much for making the time this morning, though. We're probably just going to wait another 2 minutes for people to join. Yeah, I don't know if we are good on the registration side and people registered, or we should just give it a minute or two.
The registration numbers looked good, so I'm assuming people will be joining. Maybe let's give them about 2-3 minutes.
Not a problem.
All right, then, thanks.
Thank you. But are you doing this or am I? What's happening?
What do you mean?
Oh, okay. So that means me. All right. I'm on it.
Yeah, please. I have very bad network issues today. I don't know what's happening with Vodacom. I don't know if anyone else is experiencing such, but sure, it's been terrible.
It should be fine. It should be fine. Oh, zoom in for the program a little bit bigger. Oh, that might be too much. Let's see if 125 is a little bit better. Let's see. Yeah, 150 should be all right as well. I think we can say we'll officially start at 5 past. I'm sorry for those who have, arrived early, but we won't delay it longer than 5 past. Thank you. Wilana, would you like me to perhaps stop sharing and then you can set up your presentation?
Okay.
Okay, I will stop sharing on my side. And then I'll just run through the program once everyone joins, but I think we'll also just share the program in the chat and just let people know that it's there so that if they want to see it, then no, the speakers are not muted, Meryl. It's only, oh, sorry, yes. So your speakers are muted. We'll unmute you if you'd like to make a comment I thought you meant are the people that we've invited to speak today muted. But yes, you are muted. But if you put up your hand and when we've got a question and answer session, then we'll unmute you and you'd be able to speak then. Thank you.
Are you able to see my screen?
Yes, we are, Wilana. Thank you so much.
And if I move it, you also see that, no?
Yes, we do.
Okay.
We do.
All right.
Thank you. Good morning, everyone, again. Thank you so much for joining this third session for Section 13As for the bargaining councils. I'm just going to go through some of the house rules or what we've done just as arrangements for the webinar, and then just a quick recap on the webinars that we've had so far. But thank you again so much for making the time to join us. It's really appreciated for us to have this platform with the funds and industry stakeholders to make sure that we can sort of ventilate some of these issues that we've got with Section 13As, as it is a very, very important part of the base in terms of what members actually get out of the fund. And bargaining councils and industry funds could be considered one of those very vulnerable sectors of our economy and our society in terms of the members that actually participate there. And so it's really, really important for us to get solutions that will benefit them. So just a quick thing, I think the chat is enabled today, so we will facilitate questions in the chat function and also in the Q&A. I think the Q&A allows you to be able to ask your questions anonymously if that's what you'd like, but all the speakers will give you a chance to ask questions, and at that time we will then unmute your speaker if you feel that you would rather ask your question or communicate with the speakers to ask your question verbally. Otherwise, you can always make it a written question that you ask in the chat or in the Q&A function. I'm just facilitating for the day, but I have seen that a lot of our colleagues as well from retirement funds, conduct supervision, and retirement funds in general as a department have joined for the morning. So if there are any questions that I'm definitely not able to field, then I think I have got the full backing of the entire department to be able to assist me. So we should be able to provide you with answers. And if not, then we will definitely look for someone who will. And I think that's just on the housekeeping part. But the first session that we had 2-3 weeks ago was actually for covering legislation. So we did a very nice overview of legislatively what is required. And then we had funds also talk about what their challenges and opportunities were in relation to their own fund. Our second session was very practical because we did touch a little bit on the financial side, but also then went over also just discussing the conduct standard and the very important sections that will be in effect from February in terms of what members need to or what funds need to be able to collect on behalf of members on their minimum information schedules. Today is really, really an exciting day for me in any event, because we've got a lot of the funds being able to talk today. And also from the PFA, we've also got Wilana, who will talk to some of the recent trends in cases that they've seen from the Office of the Pension Fund Adjudicator in terms of Section 13A. We will also have Advocate Khumalo, who will speak to us about the outsourcing of the recovery of arrear contributions. You'd recall in the previous session, Giabetsu did a presentation that touched on the fact that in the conduct standard, we've laid out some of the provisions that we would like funds to have in their agreements. So that would be a very practical discussion as well in terms of what funds can look for. And then we've got funds for the rest of the day. I always find that part very, very interesting because it provides you with the practical, sort of practical outlook on what funds are facing. And if there's anything I've learned so far is that the bargaining council funds are very different and there's a lot to learn. And there's a lot that happens within them that you definitely can't say they're not unique. So with that said, I'm going to hand over to Wilana. She is the new complaints manager within the Pension Funds Adjudicator's office and has been in the retirement funds industry for a very long time. We're very pleased that you could make time for us today. And in any questions that you might have, please, you can pop them into the chat for her, or you can wait until the end of her presentation for you to ask questions, just up until the next presentation. Otherwise, you can also just have them on hold until the end of the session. I'm hoping that you'll still be available then. But thank you very much for joining, and I'm going to hand over to you, Wilana. Thank you.
Thank you very much. If you can just allow me to stop sharing for a quick, just for a minute, I will be back just now. Thank you, colleagues. Good morning. Can everybody hear me?
Yes, we can hear you, Wilana.
Yes, we can.
Thank you. Good morning, everyone. We are entering the last month of this year, and I hope you all will have a well-deserved break before tackling the new year. Thank you for inviting me as a speaker on this last day of the FSCA's webinar month. I was requested to speak about the Section 13A trends picked up by the OPFA on cases submitted to our fund, to our office. Sorry. The last 2 Wednesdays saw a lot of discussions around Section 13A and Regulation 33 compliance that deals with the timeous payment of contributions and submissions of schedules by the employer to the fund, and then the fund's duties to monitor and ensure that the employer complies with the payment of contributions. So to kick off, in terms of, okay, now my cursor thingy is not working. Okay, to kick off, in terms of Section 37(1), it must be noted that non-compliance with this Section 13A is an offence, and if found guilty, a person can be fined up to 10 million rand or up to imprisonment of up to 10 years, or both. And if we move over to the duties of the employer, in terms of Section 13A(1), B, A and B of the Pension Funds Act and the rules of the fund, the employer has a duty to pay contributions and submit schedules in terms of Regulation 33(1) of the Act. Contribution schedules submitted by the employer must include minimum information, for example, the name and registration number of the fund, contribution period, name and address or pay point of the employer, responsible person to contact at the employer, identification details of the member, date of membership, percentage or amount of contribution split between member and employer, as well as an indication of any additional voluntary contributions. Contributions must be paid directly into the fund's fund bank account in such a manner for the fund to have received it no later than 7 days after the end of that month for which contributions are payable. Ordinarily, the fund administration requires a member's withdrawal claim form signed by her or him and stamped by the employer in order to pay the fund credit. It is therefore the duty of the employer to submit the complainant's withdrawal claim forms to the fund together with all supporting documents. And this will allow then the fund to determine which benefit is payable and to make payment accordingly. On the other hand, the duties of the fund is to take all reasonable steps to ensure that contributions are paid timeously. Where the fund found that it is evident that the employer failed to submit a withdrawal claim form to the fund on the complainant's behalf, the fund must allow the complainant to complete the form together with his or her ID or bank details and accept it without the employer's stamp or signature. From our side, we found that some funds have resorted to approach us as well to issue determinations against employers for non-compliance with Section 13A. And although this is allowed under the Act, it does not absolve the funds to take other reasonable steps to ensure that contributions are paid timeously. And in some instances, the dilatory conduct of the funds to take action has resulted in employers going into voluntary liquidation to avoid the debt. Also, we saw some funds, such as the Transport Sector Retirement Fund, the Motor Industries Provident Fund, and Auto Workers Provident Fund, that have implemented recovery processes and therefore have a higher compliance rate. In contrast, PSSBF has a higher non-compliance rate, and the majority of the complaints relating to withdrawal benefits relate to the PSSBF, and this has to do with employers failing to pay over contributions to the fund. So, what stands the fund or the fund administrator to do where an employer is non-compliant? Here we have Regulation 33 as guidance as to what process the fund or fund administrator can follow. So here's a quick summary of what needs to happen where an employer and a member failed to submit contributions or pay all contributions in full by the 7th of each month. The administrator, it is recommended that the administrator should within 3 days contact the employer to solicit payment. By the 22nd of the month, the administrator must report this non-compliance to the monitoring person or the principal officer. Also, by the 22nd of the month, the administrator, monitoring person, or principal officer must report its non-compliance to the Board of Trustees, which in turn will then decide when they will inform members and advise the registrar of the actions taken. 90 days after contributions were due, but within 14 days thereafter, the monitoring person or principal officer report the employer to the NPA, and within 14 days after the 90-day period has expired, the monitoring person or principal officer submits a second report to the registrar, and then it is then with the registrar to report the non-compliant employer to SARS. So this is a short summary of what processes can be followed for the fund to take all reasonable steps to recover arrear contributions. With arrear contributions, we are looking then at payment of late interest as well. That is the late payment interest is calculated according to the Induplen rule, and this rule is a principle of our common law which regulates how much interest can be charged on a debt. As per the SCA court case, Standard Bank of South Africa versus 108 Investments, it provides that interest stops running when the unpaid interest equals the outstanding capital. When, due to payment interest drops below the outstanding capital, interest again begins to run until it once again equals that amount. The rate of interest was prescribed by the then Registrar of Pension Funds in terms of Section 1387 of the Act in the Government Gazette of 12 May 2010. My presentation will be available afterwards for to scroll through the rest of my slides. I'm not going to touch on each and every one. I'm just going to highlight specific points. So the Induplen rule forms part of South African law, as also reaffirmed in the Constitutional Court in the matter of Paulson and another versus Slipknot Investments. Paragraphs 42 to 45 specifically dealt with this Induplen rule, and it says there in paragraph 42 that the Induplen rule is a long-standing and a well-established part of our law. It provides that arrear interest ceases to accrue once the sum of the unpaid interest equals the amount of the outstanding capital. When we move over to paragraph 43, it says the Induplen rule is in fact an aspect of daily economic life under our common law. And paragraph 44 says the overarching purpose of the rule is to protect debtors from being crushed by the never-ending accumulation of interest on an outstanding debt. So that was enough said on that. From our side, the FSCAs did a survey in June 22, and it showed that in nearly 40% of active retirement funds, the employer was in some form of financial distress because they and the employees approached the fund to ask for a temporary suspension or reduction of retirement contributions due to COVID-19 lockdowns. Several employers have also gone through liquidation, thereby impacting funds and members. And the termination of funds is of concern as it places fund members in a precarious future financial position. And this is likely to result in an increase in complaints pertaining to exit benefits unless proper communication is put in place by the respective retirement funds. The issue of arrear contributions remains a concern in the short to medium term, as reflected in our annual report of 2021-2022, where the majority of complaints related to withdrawal benefits was at approximately 45%, compared to 2020-2021's 24%. So that is a huge increase. And Section 13 A compliance at approximately 40%, which deals with non-payment of contributions by employers. and funds not adequately discharging their obligation to ensure collection of these contributions. Combined, these type of complaints attributed to more than 85% of the total complaints for the year of 2021-2022. Yeah, my cursor was just not working well with me, sorry. Non-compliance and delays features consistently over the years continue unabated to the detriment of pension fund members, as the impact of such failure is that members will receive reduced benefits on retirement, and their families are also often left in the lurch should they pass away with the burden of unpaid risk benefits, for example, funeral and lump sum death claims. The OPFA continues to engage funds and administrators that contribute the most to these matters and provide them with guidance on how to resolve some of the issues raised. There's regular engagement with the FSCA management on trends that emanate from the complaints management process and identification of funds that require intervention from the regulator. Participation in pension fund industry conferences and seminars also provide an opportunity to have the critical issues around non-compliance ventilated. Moving on to OPFA recent cases, the next few slides are about 3 examples of complaints that was dealt with by the OPFA related to Section 13A non-compliance and Regulation 33. I will provide background of each case and will highlight the outcomes, and you are welcome to scrutinize the rest of the slides afterwards. So in our first case, about Section 13A non-compliance, being J.R. van Wyk versus Metal Industries Provident Fund. The employer failed to pay all contributions on behalf of the complaint, on behalf of the complainant to the fund. The result of the employer's non-compliance affected the complainant's fund credit as well as his risk premiums, and the complainant was still employed and an active member of this fund. The fund indicated that contributions were received on the complainant's behalf for the period January 2012 to June 2018 and September 2018. But outstanding contributions are for the period July 2018 to August 2018, and then October 2018 up to March 2022. The actions that the fund took was to send out non-compliance letters to the director of the employer and all the parties involved, and they made the employer also sign an acknowledgement of debt. The adjudicator's determination found that that it was not enough just for the fund to send out non-compliance letters. It should have notified the employees of the employer's non-compliance and taken legal action against the employer. She found that the employer was non-compliant and the employer was ordered to pay all outstanding contributions for the period mentioned by the fund. So the next slides just confirm that the fund can proceed with legal action against the employer as well. Okay. When we go to our second case, our second case was about the employer's failure to submit Provident Fund contribution schedules to the fund and to pay all contributions. And it also related to the employer's failure to pay late payment of interest on arrear contributions. It also looked at holding persons who are involved in the management of the employer's financial affairs accountable and possibly personally liable for non-compliance with the Section 13A of the Act. The period for the arrear contributions was for April 2020 to August 2021, and the actions taken by the fund to recover this outstanding arrear contributions, they sent Section 13A letters to the employer on the 19th of November in respect of the outstanding contributions and schedules for this period. And they, even prior to the COVID-19 pandemic, they held meetings with the employer to ensure that contributions and schedules are paid and submitted timeously. The fund informed the employees via letters, via SMS, of their employer's failure to report contributions to pay contributions on their behalf, and that they have forfeited their risk cover. They also held a meeting with the employees at the premises of the employer's office to inform them that the employer is still in arrears. The outcome of this, the adjudicator's decision was then, finding was that all reasonable steps were indeed taken by the fund in this matter to recover the outstanding contributions from the employer, and it was also timeously done. She also referred to Section 13A(8) that was introduced to enable the fund to identify and hold persons who are involved in the management of the employer's financial affairs accountable and possibly personally liable for non-compliance with Section 13A of the Act. And therefore, in terms of Section 13A of the Act, the OPFA can hold Mr. Muruti, who was the manager of this employer, and Mr. Mugoji, that was a CFO, jointly and severally liable for the payment of the outstanding Provident Fund contributions and late payment interest. In summary, the adjudicator ordered that the employer, Mr. Muruti and Mr. Mugoyi, are jointly and severally liable to provide outstanding Provident Fund contribution schedules for the period in question, pay the arrear contributions, and pay late payment interest on the arrear contributions, and such amount should include whatever additional late payment interest is owing to the date of payment. Right. On our last case, we have an example of the effect of Section 13A non-compliance on risk benefits. The background here was that the administrator submitted the deceased applied to receive an income from the permanent disability scheme, and his claim was rejected in June due to arrear contributions. Subsequently, he also passed away, and the administrator also submitted that contribution that needs to cover the cost of death benefits are in arrears and therefore no insured benefit is due to the deceased. The adjudicator's findings in this determination was that the fund failed to take action to recover outstanding contributions timeously, and they didn't take all reasonable steps to recover this outstanding contributions. Even though letters were sent to the director and all parties were informed of the non-compliance, it did not appear that the fund reported the employer for non-compliance of Section 13A of the Act to the FSCA. The employer it was found that the employer is responsible for the repudiation of the risk benefit, and it was ordered to pay arrear contributions plus the risk cover amount due to this employer's responsibility for the repudiation of disability risk benefits. And that is the end of our presentation for today. I hope you found it informative, and it is clear that this non-compliance is a huge part of our complaints that comes to our office and that we need to deal with, and that we need everybody's contributions and efforts to minimize the occurrence of this non-compliance that will affect members negatively in the long run. Thank you so much.
Thank you so much, Wilana. That was actually, not actually, but it was really great. I think it's always great to touch base with, the type of practical issues that, affect members that you see more regularly than perhaps, everybody else that is attending the webinar. There are two questions. I think one is definitely directed to you, or one that you would be best placed to answer. Anton has just asked in the chat, in the PFA determinations, such as the municipality gratuity case, were the outstanding amounts actually paid after the determination was handed down?
That I cannot confirm straight away. I can come back to the person. We can send me an email and I can just provide him with the outcome there. I think of my colleagues that's with us today, it's none of the departments that dealt with this specific fund with the defaulting non-compliant employer. Can I give my email address and then the person can email me?
Yes, we'll just share it in the chat, and I think maybe for everybody else as well, at a later stage,
yes,
that might be interested in finding out. Yes, I see Melissa Botha would also be.
Can I maybe just help there on that question from Anton?
Thank you, Naeem.
We wouldn't know. We issue the order. We don't have an enforcement mandate. So we would make an order to say that the municipality must pay, and it will be up to the fund then to enforce that order. So we wouldn't have that information with us.
Thank you, Naeem. There's just also another question here that relates to the induction rule, and they're asking if it applies to determinations on single members where the interest is more than the contribution.
Yes, Takalani, the induction rule will apply it's part of our common law, and it's not been excluded by the legislation. So yeah.
Oh, sorry. I was now still muted. I was just saying that I think, I'm not sure whether the next one from Ian Riches is a comment or a question, but it's got a question mark, so I'm going to read it as it is. It seems that approaching the OPFA rather than SAPS with the MPA is far more successful in getting the arrears paid. I don't know if you could comment on that, Wilana and Naeem.
Well, if that is the case, then we are glad we have served our purpose. It also, I suppose, it depends on the position of the employer itself as to whether they can pay up the arrear contributions and where that will leave the fund for the balance to recover the balance, or that they did actually get all the arrear contributions paid up. Thank you so much.
I agree, Wilana. If it's that it does get implemented on that first time when it's issued, then it becomes so much easier in terms of costs as well, even for the fund to be able to approach your office first, or members for that matter, instead of going the legal route, because that will be actually costly for them. Naeem, did you want to comment?
Yes, I was just going to say what you just said. It's definitely cheaper to come to us than going and paying attorneys to approach courts. Yeah, I would suggest funds should rather use the adjudicator's office. Yeah.
There is a question, Wilana, I think it was part of your slides though, but perhaps you could just then go over it again in terms of where is the criminality of non-payment of contributions? And that's from Basil Maseko.
Sorry, Takalani, just repeat the question.
He's asked, where is the criminality of non-payment of contributions?
So if I can just assist there, it's contained in section 37(1) of the Pension Funds Act, which says that if you breach section 13A, then it is a criminal offense. And if I'm correct, it says that a person who breaches section 13A be held liable on conviction to a fine not exceeding 10 million rand, or to imprisonment for a period not exceeding 10 years, or to both such fine and imprisonment. So it's contained in section 37(1) of the Pension Funds Act. Yeah.
And I think the last question that we'll be able to take just before we can start with the next presenter would be, how does the fund enforce the determination in practice, and who pays for this? Advocate Khumalo, Sandile, you want to take that, or ready to start your presentation?
I think it's part of my presentation, so can I deal with it as part of my presentation? Not
a problem. That's why I was saying already that I think you're actually going to deal with it as part of your presentation.
Yeah, can I just add that when we issue out our determinations, it's normally issued with a covering letter, and the letter will inform you if you want to enforce the determination, you may need to approach an attorney to assist you. If you cannot afford an attorney, you may need to go to legal aid. But basically, when we've been trying to make orders that are sounding in money, what that means is that our order will say the employer is ordered to pay X amount to the fund, and in the hope that that is easier to enforce than the other type of order, which would require you to sort of exchange information between the parties, and then there must be a calculation done. And in order to enforce that type of order, then you need to go the contempt of court route. But I'll leave it for Advocate Khumalo to take it further when he's dealing with the matter.
Thank you very much, Naheem. I just want to see that we can start with Advocate Khumalo's presentation, just on our side to see whether we can share. And we will also share the slides. I see there have been some questions about whether the slides will be available. They definitely will be available together with the recordings of the sessions as well. We had just then been waiting for this very last one so that we could put everything together and then have it available on our website. Our next presenter is Advocate Khumalo, who has had probably too many years, I don't want to say a lot, but too many years in the retirement funds industry, practicing as well as an attorney in this space. And he's also serving as a trustee on numerous funds, independent trustee on some funds as well, and is currently also a statutory manager on one of the industry funds that we have. So he's got both a legal side and I suppose also a practical side in terms of, enforcing trying to recover their arrear contributions in over many years. So thank you very much for having the time to come to us to present as well and be part of this webinar. We really appreciate you being able to share your knowledge with us today. And I'm going to hand over to you. Thank you.
Morning, everyone. Is it okay if I switch on my video, Takalani? And Kevin?
Yes, it's okay.
All right.
Definitely.
I'm not sure if I'm sharing the slides or somebody's sharing the slides because I'm not very good when it comes to this thing of sharing slides on MS Teams, so you will forgive me. The slides are numbered, so I think whoever is sharing the slides, what I will just do is say, can we move to slide number 2, slide number 3? And then whoever is sharing the slides on your side can assist us with that. So thank you very much. Good morning, colleagues. Good morning, everyone. I'll be talking today about the outsourcing of the recovery of arrear contributions. I want to just make an observation, and this is from personal experience. Non-payment of contributions by employers is costly. And it is not costly just for the members who in the end do not receive the full benefit of their salaries, which are deducted for the purposes of paying to a contribution to a pension fund with a view to contributing towards your retirement benefits so that when you retire, then you get paid. It also costs members whose employers are contributing to the fund a lot of money. Because typically what happens in big funds where there's a lot of non-compliance with 13A is that contributions of members whose employers are compliant end up being used to chase after employers who are non-compliant. And in that way, compliant employers end up subsidizing non-compliant employers. And in those funds where the problem is too big, you can imagine that it becomes a problem and it becomes controversial, because what compliant employers and compliant members often ask is, but why are you using our contributions to chase after non-compliant employers and to benefit employees of non-compliant employers? Because even if you do recover, I do not get that money back. And the expense you've deducted from my contribution to chase after that non-compliant employer, you don't pay it back even if you do make a recovery. So members are very unhappy that they have to subsidize this thing of recovery of arrear contributions. And arguments on the other side are that, look, when you are a member of a pension fund, there is inevitable cross-subsidization. But the reality is that it was never meant to be at that level. So 13A is very difficult. And I'm glad that the question that was asked has been asked, because what often happens is if there's a complaint to the adjudicator and the adjudicator issues a determination, most of the time employers against whom determinations have been issued do not comply, which means a pension fund or the member in whose favor a determination has been made inevitably will have to engage lawyers to execute and follow the execution process, which, believe it or not, can be just as costly as initial litigation and take just as much time as initial litigation. Because most of the time, these employers that are non-compliant when it comes to 13A are also non-compliant with regard to their obligation to SARS, with regard to their obligations in relation to levies and other issues. So the fund is not first in line just because it has a determination. And on the other side of the determination, it becomes a big problem because, yes, you've got a binding determination, but there are other creditors that are waiting in line that are also looking for money from that employer. So 13A gives all of us a headache, and FSCA, I'm turning gray because of that. So if I can move to my presentation, slide number 2. The previous speaker has already touched on this, so I'll deal with it very briefly. 13A3 of the Pension Funds Act says contributions must be paid within 7 days of the end of the month. You can pay them earlier, but the Act gives a grace of another 7 days for the employer to pay contributions. Obviously, the contributions must be followed by schedules, which is also a big problem because it impacts on allocation of contributions. And this is the position with regard to both underwritten and privately administered funds. And then 13A7 says if contributions are not paid as provided for in 13A1, then interest is payable from the 8th day. The 8th day is the first day after the expiry of the 7-day period. So arrear contributions, for the purposes of our presentation, include contributions proper, but also late payment interest. So when we talk about arrear contributions, we're referring to those two elements of a contribution. Can we move to the next slide, please? So Section 7D of the Pension Funds Act imposes an obligation on the board to take reasonable steps to ensure that contributions are paid timeously to the fund in accordance with the Act. Now, this section is very vague and somewhat controversial because at first blush, it creates the impression that it imposes an obligation on the board before a contribution is paid. So in other words, before the 7th of the following month to take reasonable steps. It doesn't in so many words say when there has been non-compliance, then you must take steps. And this issue came up in the joint municipal pension fund case in Tanzania, where in fact, the employer objected to a pension fund seeking payment of arrear contributions from it by way of court action. And the employer said, well, you don't have standing as a pension fund to sue me for arrear contributions. And the court had to deal with that matter and said, in the circumstances of this case, the fund is obliged statutorily to collect the contributions and to distribute the benefits payable to the members as appears in 7D. And that means it also has the right to institute a claim for payment of contributions. And that falls squarely within the concept of reasonable steps to ensure that contributions are paid. But how the court dealt with this issue here was different because the court did not say, in all circumstances, you must sue as a pension fund. It said in this specific case, because there was non-payment by the employer, and the pension fund took steps, legal steps to recover from the employer, it was not only entitled but obliged in terms of the Act to do so. So you would have various cases, for example, where in industry funds, contributions can be as little as 200 rands a month, as little as 400 rands a month. And as you know, lawyers are expensive. I mean, the going rate at this point is about 4,000 an hour, 40,000 a day. So you can imagine if you've got an employer who owes 10,000 rands in contributions, it would simply not make sense in those circumstances to sue that employer, because the amount of money you're going to spend bears no relation to the amount of money you're trying to claim to that from that employer. So litigation is not always the answer, and it makes sense in those cases where the employer owes a lot of money, and you know that regardless of how much money you spend, you are likely to recover something which is substantial. Because one of the mistakes you don't want to make, or the risk you don't want to take, is to spend a lot of money to recover very little. Because at the end of the day, the fund loses and does not get anything. So it's not always the answer to say reasonable steps in every circumstances where an employer has not paid is to sue that employer. And as you know, litigation also takes time, and every instance of non-payment every single month is a new cause of action. So if you were suing a single employer for non-compliance, you would constantly have to amend your papers every month or file new summons every single month whenever there's a breach of section. Hi, can you still hear me?
Yes, you did have a moment there where we didn't, but now your sound is back here.
Hello?
Hello?
Yes, can you still hear me?
Yes, I can hear you.
Hi, can you hear me?
Yes.
Can we perhaps please ask the advocate to leave the meeting and then rejoin? I think he might be having a connection issue. If he can hear us.
Yeah, that's the big question now, if he can hear us. Let's see, just to perhaps break for 2 minutes, so I can just call him and then see how we can resolve it. Thank you.
Hi, can you hear me?
Yes, we can. Can you hear us now?
I can hear you. I don't know if
Oh,
it was load
fantastic.
shedding or something, but it just went off and we got lost.
All right.
The slides are no longer on the screen, so can we please share? Yes, we were on this page. I think it's page 3 of the slides. And colleagues, now that we've lost some time, I'm going to try to move with speed. But I was just, when we stopped, I was dealing with the issue of legal steps to recover outstanding contributions from employers. So can we move to the next page? Remember, our presentation is on outsourcing, and the simple point I wanted to make was section 7D says that the board may in writing delegate any of its functions under the Act to a person or a group. So if you look at 7D and you read it together with the judgment I've just referred to, they expressly endorse outsourcing of functions of the board to other people. And the only limitation in the act is that it must be in writing and it must be in terms of the rules. So a pension fund must always be aware of what its rules say. And when they're outsourcing the collection of contributions, they must do it in writing. It cannot be a verbal outsourcing. And the issue of outsourcing is not new because it applies, in fact, to most, if not all, pension funds. But in practice, the outsourcing is to administrators. So it's a function that is delegated to the administrator of a pension fund, and that is done in accordance with the SLA that the pension fund has with the administrator. Next slide, please. So in simple terms, contributions are collected, and when they are paid on time, there's no problem. But how the outsourcing works where contributions are not paid on time, the Section 13A process, read with Regulation 33, is then followed, where the administrator will do the basic and non-confrontational method of collecting contributions, such as writing reminder letters to employers, writing 13A letters to employers, and making telephone calls and those kinds of inquiries. Now, I sit on boards of pension funds where there's like 8 or 9 participating employers, and in every single one of those employers, we know who the HR person is. So if contributions are a few days late, it's very simple to contact those people and say, what's the problem? Why have you not paid contributions? And you get an immediate answer. The story is different where you're dealing with industry funds and it's thousands of participating employers that are participating in that fund with multiple pay points. So not just one HR, but 1,000 employers with even 1,000 more pay points, and it becomes very difficult. So in simple terms, where everything works, outsourcing is done to the administrator, and the administrator is responsible for collection of contributions. Can we move to the next slide, please? Slide 6. The more difficult cases require lawyers because where the administrator has not been successful recovering contributions from the employer, it is inevitable that the next step will be litigation. I can honestly tell you that there was one instance where we went to SAPS to report an employer for not paying contributions. And SAPS said to us, we won't open a case unless you bring pay slips of all those employees. Because it's a fraud issue, we want to see for certain that the employer has deducted from their salaries and not paid to the fund. So go and collect those pay slips and bring them to the investigating officer before we can even consider moving forward. So you can see that as much as the SAPS route is available, it's a very difficult one. There was a recent case in Cape Town, which was in the news, one of a few success stories where there was actually a conviction for non-compliance with 13A. But those cases are very rare and they are few and far between. So the most likely route most of the time will be the involvement of lawyers. And as I said when I started in my presentation, lawyers are expensive. Most, if not all lawyers that I know, they charge per hour and they charge a daily rate and they charge for the work that they have done. Next slide, please. And the problem with the involvement of lawyers is this. Lawyers get paid regardless of whether they win or they lose a case. And that's how our legal system works. So if you were to institute proceedings against an employer and you are unsuccessful for whatever reason, the fund loses out. And in my experience, what I have seen, every time you try to go to court on an application, remember in court proceedings, there's a difference between application proceedings, which is a notice of motion, an affidavit, and summons proceedings, which are action proceedings. If you try to go the quicker route of an application proceedings, the employers simply dispute your calculations and they create a dispute of fact. And the matter ends up dragging for 3 to 4 years over something that's small, just to avoid having to deal with it on motion and it becomes very difficult, it becomes very costly and time consuming. So the question of how litigation costs are funded, especially if litigation is only going to benefit employees of non-compliant employers, it's a controversial issue. I started with it when I was starting my presentation. So cost of litigation can sometimes exceed the cost of recovery. So although it's noble to go the litigation route, in the end, you end up not recovering what you had in mind when you started. And ultimately, as the speaker from the PFA has just said, it is the members who lose out, because if you're not going to recover what was due to the fund by way of contributions, then the benefits of members are also going to be low. And then the last point on that slide is employers who do not pay contribution to pension funds usually have other problems with SARS and other people and levies and the like. So the likelihood of a full recovery is always slim when you are dealing with non-compliant employers, because they are non-compliant because they have other issues as well. Slide number 8, please. And I think this is one of the questions that was asked after the previous speaker presented. Litigation does not end with a pension fund obtaining a favorable judgment or with a complainant obtaining a favorable determination from the adjudicator. What follows thereafter is a process of enforcement, and it costs a lot of money for pension funds because it is administratively intensive. Usually determinations require that the administrator calculate the amount that is due from the employer at the end of the determination and also interest. And the employer is then given that amount and they are required to pay the amount to the fund within 2 weeks. On most occasions, it does not happen. Even if a calculation is made and given to the employer simply does not pay, even after there's a judgment or a determination. And that requires that either the member who lodged the complaint himself or the pension fund must now enforce the determination. And enforcement most of the time requires the involvement of lawyers. Naeem, you'll assist me on this one. As far as I know, and those from the adjudicator's office, as far as I know, determinations are filed with the court, and once they are filed, they acquire the status of a court judgment. So what then happens is that whoever wants to enforce the determination can just follow the enforcement proceedings. What you cannot do is enforce it by way of contempt. There's a judgment from 2015 involving the Thamani municipality, and it was penned by my colleague, Acting Judge Durance, who said because determinations of the adjudicator are not high court judgments, if an employer does not comply with the determination, they are not in contempt of court. So that's another layer that delays the process. But the long and short of this is that to enforce judgments and determinations is also costly, especially in industry funds where businesses get open and shut all the time and they change hands all the time. I mean, you'll be surprised that in industry funds, you find that the owner of the business is actually a 14-year-old child of the person who's the brains behind the business. And when you dig deeper and you look at who's the real owner, who runs this business, it is somebody else. But in the documents that you have about who the owner is somebody completely different, somebody who you cannot even sue to get contributions from. Next slide, please, number 9. So this is now the alternative method, because remember, ordinarily a pension fund would just go to attorneys, instruct those attorneys, and pay them to enforce the judgment or to start or initiate proceedings where you're claiming outstanding contributions from employers. And the issue there, as I said, is the cost, who's going to pay and who's going to share in the costs. So an alternative method that has gained traction is the one where risk is shared between the law firm and the fund. And I will try to explain how that risk is shared. So you appoint the law firm on a contingency basis, and you're saying to them, I'm not going to pay you upfront, or I'm not going to pay you per hour or per day for the work that you do. I want you as a law firm to invest and use your own money and resources and time to recover arrear contributions for me as a pension fund. If you do recover something, then you will take a share of whatever it is that you have recovered. So that way the fund never has to spend money. But the downside of that is if there's a recovery, then the attorney gets a portion of what is recovered, and the fund does not get the benefit of a full recovery. So that's typically how that works. And I think you'll see from the conduct standard, that's really what the FSCA tried to regulate by saying, even in cases like this, although we do not encourage or discourage it, be careful about conflicts of interest, be careful about the types of contracts that you enter into, and also be careful about the percentage. So how much of the percentage of the recovery goes to the employer? Although FSCA does not seek to regulate it, they still say in terms of your duties as a pension fund, be careful and make sure that the amount is not excessive. Next slide, please, which is slide number 10. This is what I was talking about. Attorneys charge a percentage of arrear contributions recovered, and they act at their own risk. If they do not make a recovery in respect of a particular employer, they do not get paid. That way, you don't have a situation where members of compliant employers are subsidizing never-ending litigation that will only benefit members of non-compliant employers. The incentive for attorneys is that the more they collect, obviously, the more they earn. But the risk is that if they do not collect, they have used their resources for nothing. Next slide, please. Slide 11. Even under this method, I must make it very clear, successful recovery is not guaranteed. Because typically what employers do, when you involve attorneys, they negotiate and negotiate and negotiate. And some of them enter into acknowledgement of debt agreements, and you enter into 2-year agreements where they say, we will pay the outstanding contributions over 2 years. Please do not sue us. And they start very well for the first 2-3 months they pay, and then after that they stop paying, and you are back to square one. So it has its ups and downs and its pros and cons. Something that is dealt with in the conduct standard is the issue of conflict of interest, and it's a risk or a disadvantage that one must look at. Attorneys placing their interest above those of their funds and pursuing only those cases where they feel that chances of recovery are high, and therefore they'll also earn fees by doing that. The disadvantage, as I said, for the fund is it gives up a higher percentage of recovery in exchange of getting something without having to spend money for it. So pros and cons on both sides. Can we go to slide number 12, please? Let's just look at the time. I have another 3 minutes, I think. So I want to conclude by saying outsourcing is expressly permitted by Section 37D of the Pension Funds Act, and that there are traditional and non-traditional methods of outsourcing. The most obvious one is where you outsource to your administrator, but if your administrator is not successful, you brief an attorney directly and you brief them the same way you would brief an attorney in a contractual dispute or any other dispute. You pay them their fees per month, per day, and they do the work for you. And if they are successful, then you get the recovery. The non-traditional method is the one where you go the contingency agreement route. And in my experience, no one method is better than the other, and no one method results in more success than the other. But obviously, with the contingency one, when members and employers that are compliant come to you, you are able to say, I'm not using your contributions to fund recovery and to chase after non-compliant employers. And they tend to be comfortable with that because they don't want a situation where they are up to date and they're complying, but a substantial portion of the contributions that they pay for their members ends up being used to chase after employers that are not compliant. So the impact of the conduct standard, my understanding is that it's going to come into effect sometime in the first quarter of next year, if not the second quarter. And the idea, as I understand it, is that the FSCA and Treasury wanted to replace Regulation 33. And when it does so, it will deal with various other issues relating to contributions. And then on the issue of outsourcing specifically, I think it's on page 5 of the current version of the conduct standard. FSCA neither encourages nor discourages outsourcing to lawyers. It simply says if you're going to do so, you must be careful. And these are the things you must look at, including the fact that there must be a written contract and you must exercise care and diligence in terms of fees and conflict of interest. And in a way, it codifies existing law. I do not believe that it changes the law in any way. But the difficult answer is really, the difficult question remains the question of cost. And cost is not just the cost of the lawyers. It's the amount of time it costs pension funds and administrators to deal with non-compliance, especially 13A non-compliance. I mean, I sit in a fund where my administrator spends more time chasing after non-compliant employers than servicing compliant employers. And it's a big problem. So I don't know if there's an answer, to be honest with you. And all of us are here, I suppose, to learn from each other and to see if there are ways that we can improve the situation, because it's a big problem. It was especially worse during COVID. So the last 2 years, 2020, 2021 was especially worse. I think it's much better this year, but hopefully it will improve going forward. So can I hand back to the facilitators of the discussion? And if there are any questions, then I can take questions. Thank you.
Thank you. I see there's a hand from Naim.
Yes. Naim, I hope it's not a difficult question. I know you like asking difficult questions.
No, but it's going to be because, you know, Advocate Khumalo, even when I was at the FSCA, we had this discussion about contingency fee agreements and why I don't think it's the right way for you to be going. I know you've got the other view, and I'm glad you touched on the disadvantage of it, but you didn't go into detail and you didn't explain properly, I think, what the disadvantage is, because most attorney firms, when they take on risk, they're taking it on at 25% of the amount. And if you had to instruct the attorney in the normal course, it's a small percentage of that 25% that you would have to pay. You said attorneys are charging 4,000 Rand an hour. Maybe specialized attorneys are charging that. Your collections attorneys are not charging that. They are charging tariff to recover on judgment debts. So if we issue a determination, then it does have the same status as a judgment of a court, and you can enforce it in the same way that you can enforce a court order. So I wanted to touch on that and say, in my view, I don't think that your non-traditional method of entering into contingency fee agreements is in keeping with fiduciary duties. I don't know if you were trying to convey that the FSCA endorses this approach of contingency fee agreements. I don't think they do, but maybe I'm wrong, because I'm no longer there, so they might have changed their mind about that. But for me, I mean, if I had to project to you, I just quickly Googled what is the magistrates court tariff, because when I was in practice the last time, this was about 7 years ago, the magistrates court had jurisdiction up to 300,000. I don't know if that's increased, or it should have by now, but you can see the amounts that is charged on a tariff basis. for the different types of actions that are taken during the course of a recovery. And I think if you enter into a contingency fee agreement, then it's going to far exceed that. So I just thought I should put my view forward. Thank you.
Yeah, thank you for that, Naim. You and I know we've had a long discussion on this, and it would probably take 2 hours. As I said in the presentation, FSCA neither encourages nor discourages, for good reason, because the duty of recovery is the duty of the fund, and the fund must exercise judgment. I think that's what expected of any fund, to exercise judgment. And the method you follow would depend on the amount you're recovering. I mean, you're quite right. For example, where there are adjudicator determinations, because you already have a determination, if you go the contingency route, you would be mad, because you already have a judgment, so all you're doing is execution. It's a different story when you're starting from scratch, because there the position is different. And also, depending on whether you're going the Match Court route or the High Court route, those of us who've litigated in the Match Court will tell you that the experience is not always pleasant. So again, it requires exercise of judgment from each fund, depending on the type of matter, the complexity of matter, and what you're seeking to recover. I'll give you a live example. We litigated in the High Court in Durban a couple of months ago, and we ended up having to brief a senior counsel simply because of the complexity of the matter involved. Induplum came up, prescription came up, various other contractual issues came up, and that necessitated instruction of counsel. But in simple, straightforward matters, you're quite right. One has to exercise judgment and say, look, how much am I recovering? If you're recovering 20,000, for example, both the traditional and non-traditional methods do not make sense. What makes sense is for you to negotiate a fee with whoever you are briefing and saying, look, I'm not prepared to pay you more than 5,000 rands, but can you recover this 20,000 rands for me? So, I mean, I don't even know an attorney in his right mind who would say, I would want 25%, where they're only looking to recover 20,000. So at every case, I think you have to assess it on its merits, and trustees have a fiduciary duty. You have to exercise judgment, and how you do that, will be judged, I think, at the end of the day, based on whether you were successful or not, and what steps you took and how much money you paid. But I don't think, that's why I cannot advise, I mean, in this forum, whether the traditional is the better method or the non-traditional is the better method. All I will say is there are those methods and they are being used, and sometimes they are used successfully and sometimes not. So thank you, Naim. And I'm sure you and I will have more discussion even on this outside of this platform. I'm just mindful of time. I don't want to take time of the next speaker. Thank you.
Yeah, I think we've gone a little bit into the next speaker, but I'm just worried that we might not have you available at the end of the webinar. So I'm going to try and facilitate just quickly. I think we've got 3 more questions, and then we'll see to go into a little bit more time on your session. Mr. Assad, oh, sorry, Adam, you can go ahead with your question.
Good morning, everyone. Thank you, Advocate Khumalo, for really a very insightful presentation. So thanks for that. I think I just want to ask, are you familiar with certain industry funds where we have what we call the Dispute Resolution Center, which is sort of delegated under the CCMA? Now, in your view, and sorry to put you on the spot, if the DRC follows all its processes, issues a determination, and then can't collect the money, in your view, would the trustees have taken all reasonable steps?
I mean, my understanding, and I know specifically in the auto industry space, there is such a forum. Yes, because remember, it's almost like it's the same as the adjudicator. And my understanding in those funds, for example, where the fund has referred, the case to the forum, and the forum has issued a determination, and their compliance, enforcement mechanisms being implemented. Oops. Am I back? Hello?
Yes, you are. Yes,
Sorry,
you are.
it kept going on and off. Remember what I said in relation to the judgment of the full court. Reasonable steps depend on the circumstances of the case. So no one can come to you and say reasonable steps in every case means you must do A, B, C, D. The mere fact that the word reasonable is being used, it means, it's relative, and it's a value judgment thing. Everybody exercises judgment and they say, well, in the circumstances of this case, I think this is reasonable. I think this is not reasonable. But where those steps have been taken, in my view, and I say this without giving legal advice because it might come back to bite me, I think those would be reasonable steps. But if you are able to enforce, obviously, it will be even better if you proceed further and you seek enforcement. I hope I've answered you there.
Yeah, no, thank you much. I think this conversation will continue, Advocate Khumalo, but it will continue outside of this forum. But thanks for your, always nice to deal with an advocate, come with very practical solutions.
And they get it wrong most of the time, believe it or not.
I don't know about that. but thank you very much for your input. I'll leave the floor to someone else and we'll continue outside of this forum.
Takalani, you said there was one more, so I can take one more and then.
Yeah, there were two more. I think it's Omar. You can go ahead with your question. Omar, you have been unmuted, so you can unmute on your side. Okay, so perhaps we can go to Francois van Heerden.
Thank you, ma'am. Yeah, look, I'm from Solidarity, but I'm a trustee on the MIPFA Pension Fund. And we have successfully introduced a mechanism in our fund where we have appointed an attorney on a fixed basis. And for the last 7 years, that attorney has collected more than 1 billion rand for us. He's currently got civil and criminal matters that is currently at courts pending dates and stuff like that. And we also have some cases where he had successfully prosecuted some of the employers that failed to adhere to an agreement, because the first thing he does, he goes and he enters into a settlement agreement. If they don't do the settlement agreement, then he goes straight to civil and criminal action, because the Act says you can also follow the owners of the company criminally. So yeah, from our side, we have done a great success. And yes, if you take the cost that we paid over the time period, it is not even 1%. I think it's less than 1% that we've paid our attorneys to collect over 1 billion. Last month, he hit the 1 billion mark for us, and our members, well, I think as trustees, our members are very happy because we received quite a lot of complaints about companies that did not or withdraw the benefit and did not pay over to MIPFA. Thank you.
Yes, I know about that, by the way. So yeah, great success story. I think, Takalani, if the other person is not ready, can I wrap up by saying one more thing?
Yes, of course. And then we we'll close off.
So just in the context of the cost and recovery, there are some attorneys out there who would take matters in bulk and who would say, look, my normal rate is, for example, 2,000 rands. But if you give me 100 cases, then I can reduce that to a certain rate. So rates are always negotiable and you can play around with them. But I just wanted to focus, because I only had 30 minutes, on the traditional and non-traditional methods. Outside of that, there is the method that Naeem spoke to, and also the one that the gentleman has just spoken to, and also the one where if they take it on in bulk, then you can negotiate the fees and get a substantial discount. So thank you for inviting me. I'm going to be listening in the background, so I'm not going to leave until 12:30, so I'll still be listening. Thank you.
Thank you so much for joining us in that very, very practical presentation. I think you raised a lot of issues that have been coming up or that did come up as well in the part 1 and 2, specifically on costs. I think there was, again, a question in the chat about, where do the costs come from for the fund to be able to do this? And we had committed to making sure, as Adam has said, to make sure that we continue this conversation because we do need to find the most efficient and effective ways. And efficiency comes with, is it going to be costly or not for you to be able to do that? As one of the considerations in that process. So we need to make sure that there is a conducive environment within which trustees can operate, and members can also safely contribute. I'm going to hand over to the next presenter. I see Kia has got a hand up. It might be about time, Kia.
Thanks, Taki. No, I just wanted to say that I've noted that there are questions in the chat function that we were not able to pose to the advocate. So we've noted the questions. We will pose them to either the advocate or relevant speaker, perhaps just before we close off with the webinar. Is that fine?
Yes, no, I did note them as well. I think some of them were questions that I wanted to attend to while I was listening to the other speakers, but some of them, yes, we will have to attend to them at the end. But thank you, Gia. I'm going to hand over to Mr. Rama Govenden, who is the Principal Officer of the Furniture Bargaining Council Provident Fund. And as we had said and made sure throughout the series to just have practical examples and learnings on this platform from different funds. And we had a pre-discussion with the Furniture Bargaining Council before, and it was quite interesting. I hope that you will find the presentation as well very insightful. And I'm going to hand over to Mr. Govenden now. Thank you so much for joining us. You're on mute.
Apologies. Thank you, Takalani. Thank you really for the opportunity to share our thoughts and ideas at this forum. My topic is going to be a little bit more mundane rather than the legal niceties that Advocate Khumalo spoke about. But really, just a little bit also, Takalani and team, congratulations on this initiative. I think in terms of the webinars, I'm sure I echo the sentiments of a lot of people. It's been hugely beneficial. I've got a lot of value from it, but also engaging with the various bargaining council funds, I think has been hugely beneficial as well. Thank you. And I'm sure that will continue so that we could actually make more progress on our side vis-a-vis Section 13A and a whole lot of other issues as well. All right, I think I'm the PO of the Furniture Bargaining Council Fund. This is a new experience in terms of the bargaining council environment. I've got lots of experience in the standalone, in the umbrellas, and all sorts of other environments. But this is something new, and yeah, it's quite a good challenge. But I'll chat further. The approach I've taken is to consult, a few more bargaining council funds. And what I've done is to distill or condense the kind of learnings from a challenge perspective or the challenges perspective. And I've come up with a few proposed solutions as well. And hopefully we could, even if we don't have time today, we could, hopefully pursue that going forward. All right, can you see my presentation? Is that all clear?
Yes, it is. Thank you.
Okay, thank you very much. All right, in terms of the agenda, I want to keep it simple. I want to do an introduction, unique environment, just paint the picture of the uniqueness of the environment. Key challenges, what are the key challenges that organizations in this environment face? And then I've come up with a few solutions that I've actually canvassed with some other funds as well, and then questions and comments, obviously, at the end. All right. I think in terms of, regarding the Furniture Bargaining Council, interestingly, it was formed in 1926. And interestingly also, the Provident Fund was the first fund that was created under the aegis of the council. And I think importantly, maybe to position up front, is that bargaining councils do a whole lot of other collections as well. And I've just listed down some. I'm sure many of the other bargaining councils have a host of other funds and schemes, leave pay funds, holiday bonus, death and funeral schemes, sick benefit, home ownership schemes, emergency trauma, disaster and education fund. So clearly, if you look at bargaining council, they have a huge admin load. So Provident Fund is one of them, but obviously, given the governing legislation, we need to pay specific attention to how we manage Provident Fund, obviously. All right, if I can then move on to the next one. Yeah, like I've said, I've been in the retirement funding environment for more than 22 years. This is the first time in a bargaining council environment, but I must say it's been fairly challenging and complex in the sense that you've got almost competing governing legislations and regulations. And obviously, in terms of a whole lot of host of admin issues that present itself within a administrator environment. Importantly, I think in terms of the uniqueness of the environment, which we've spoken about before, and other speakers have done that, you've got the LRA and collective agreements, and then you've got your PFA and the FSCA requirements that was introduced into this environment in 2007. The other characteristic feature is the composition of wards. You have equal numbers of union reps and employer reps as well, or rather employer association reps. And importantly, also the council of the bargaining council is also the 13B administrator. And I think that has particular implications too. I can just have some water. And importantly, within our fund, I must say, we've got a great dynamic. I think it's quite a non-partisan approach, which is very refreshing. One thinks about union reps on the one side and employer or employer organization reps on the other. But I found it to be very, very civil, and in fact, more than civil. I think it was quite a cooperative environment within which member interests were looked at. So I was pleasantly surprised, and I think it's a great environment that we have. I think my observation also is that given the context, and I'm not saying it doesn't apply to other funds in the broader context, I think more training is required to vest trustees in the retirement fund environment, in this environment and in the broader environment, but specifically in this environment. And I think we could chat more about that, but that's just an observation that I want to note. In terms of key challenges, I think importantly, elements of collective agreements. I've just kind of listed some of the elements of collective agreements that might actually not align very nicely with the PFA or the FSCA requirements. I think a lot of the bargaining councils have this principle that says the oldest debt is cleared first. So that poses problems, but I think we can get around that. But I'm saying that that's something we need to look at. Obviously, there's our own process within the context of bargaining councils. And earlier on, the dispute resolution process was mentioned in terms of arbitration and designated agents, et cetera. I'll chat a little bit more about that. Also, interestingly, within the context of collective agreements, I've seen some funds which levy or in fact impose a interest rate of prime plus 5, which is quite punitive, one could add. Obviously, from an FSCA perspective, it is the prime plus 2 in terms of late payment interest, but that's something we can chat further if we need to. And I think also, which is a point I've mentioned earlier, collection of many contributions for various funds. I think we mustn't underplay that this is a huge issue for bargaining councils. And if you look at it at this time, I mean, they're paying out so many benefits in terms of holiday pay, leave pay, and now with the, you know, in terms of foreign nationals, in terms of the employment bill, there've been all sorts of things, and you know that has raised a lot of issues as well. So I think it's quite a busy environment, and I think that's important to note too. All right, the questions I think we need to highlight within this context, given you know what I've said, is, and I think the challenge, and I've been looking at that, and I would make you know a broad proposal around that as well, is how do we marry the collective agreement process within the context of LRA, etc., with the conduct standard. I think that's important. And you know, when I talk to a lot of the bargaining council funds, in some ways, I think those two arenas live separately. So I think it's about saying, how do we bring it together? And I think we need to have a concerted effort to bring it together in a meaningful way. That's the first point. I would say, you know, there are two types of non-payers within bargaining council funds. That's in terms of canvassing others as well. The first type, I think you got taking the gap, and I think Mr. Advocate Khumalo mentioned that kind of type or ilk of person, where the person's taking or the individual or the owner is taking the gap, delay payments to get more interest. And I think the question of financial engineering in terms of, you know, let me wait before I pay the Provident Fund because I could get more interest, or I'm using it as bridging finance, which is a big problem. I think that is something that's experienced across the board. And the second type is the employees in legitimate economic trouble. And I think that, you know, I would like to alert the FSC to this issue as well. I know that's been alluded to over various sessions as well. The question is, how do we factor that? Because we need to, I think, ring fence employers in real trouble, in really distressed entities. How do we manage that in a different kind of way so that we actually don't tip them over the kind of precipice, as it were, but help them to you know, hopefully you know, survive and hopefully you know get onto a more sustainable basis going forward. But I'll talk to that a bit more just now. Okay, and then in terms of that as well, contracting through a payment plan, I mean, you know, in terms of companies in real distress, what are the parameters? You know, let's define parameters that would allow and incorporate this kind of solution or remedy within the processes that we're looking at. And my sense is, and you know, chatting to the various funds once again, is that it's a de facto situation that we have payment plans, and some have memorandum of agreements as well. You know, they're in place already. The question is, how do we bring that out in the open and say, how do we build that into this process? Not an easy one, but let's have a look at that. The other question, which is probably a controversial one, but I think it's a potential conflict of interest that I want to raise as well. You've got many secretaries of bargaining council that are also PO of their Provident funds, all right? In other words, you've got the secretaries that are actually running the administrator. They're the 13B administrator, and they're also the PO. So I think there's probably I would think a Directive 8 conflict there. So we can chat about that as well. And I understand fully, you know, I've you know, understanding the bargaining council environment is where money is very tight. And, you know, I mean, they run their budgets very tightly, and it's not like, you know, money is freely available. So clearly, you know, understand the economic and financial constraints, but I think one needs to look at the broader conflict of interest as well and come up with solutions. All right, these are the solutions that I want to propose, and you know, it's something that I'm putting out there, and please, you know, I'd like engagement around that. First of all, what is the metric that we can use to compare one fund with another in terms of the extent of arrear contributions? Because we say, yeah, the fund is in arrears. I'm suggesting a metric that we can use so that maybe it's useful for the fund and useful for the FSC hopefully as well. What I'm suggesting is that to define what is the size of the annual contribution book. In other words, what is the full contribution payable, not paid, but payable in that annual year, in the annual period? What is the size of the arrears? And what is the percentage arrears of the annual contribution book? For example, if the Fund A is an annual contribution book of 100 million, and the arrears on the book is 15 million, the fund arrears is 15% of annual contribution book. And it might be useful to then say, what is the, sorry, I think I ran ahead. Sorry, yeah. And then I think it's maybe a good point to say, what is our percentage of arrears over the annual contribution book, and what is our target, and how do we manage that process through an implementation plan or whatever the case is. So yeah, that will be interesting maybe to compare, and then and I understand fully the points that have been made, that different bargaining councils are in different places, in different characteristics in terms of the nature of the industry, in terms of the economic conditions, etc., etc. All of that granted. But I think one has to compare and maybe have some way of measuring, which I think is important. That's the first proposal. Second proposal is, how do we marry collective agreement processes with conduct standard? Now, in our fund, in terms of the LRA and the collective agreements, contributions should be paid by the 10th of the month following the coverage month. In other words, a month for which the contribution is paid. And obviously, we know from a 13A perspective is the 7th, and then the schedules by the 15th, the same as in terms of 13A. And some funds have exemptions. We have a 1-month exemption, contribution due a month after the coverage month. So I know that the last webinar, we did speak about that, but that would vary as well. So I think that, so just to take that process further, I know in terms of funds, we spoke earlier also about the dispute resolution process. So I'm not going to get into the detail of the process, but there's arbitration, you have an independent arbitrator, etc., compliance order. And the question I'm asking is, what happens if employers can't pay? And that gets back to the question of, how do we manage entities that are in trouble? I think, and in some cases, this is already being done. We need to lift the financial or commercial veil. In other words, if an entity is saying, you know what, we're in real trouble, then it's a question of show us your financials. And I know it's been done in the funds that I've been involved with during the COVID time as well, where there've been various dispensations. So I think this has to be used more strictly in terms of saying, all right, if you say in trouble, we want to see your financials. And I know there's a lot of financial engineering and financial manipulation going on, but I think that's a good start to engage meaningfully with employers and to look at, are these the guys that are taking the gap, or are they legitimately distressed? All right. In terms of the arbitration process, it could actually take more than 90 days. So it's quite a lengthy process in terms of engaging with the employers, getting there, investigating the issues, scheduling the arbitration itself, and issuing a compliance order, blah blah blah. So what I'm saying is that my point is that that process can run its course, but what I suggest is that the timelines and the engagements that are required vis-a-vis Section 13A can be built into this process. So your 15-day, your 7-day, your 30 days can be built along the line of the 90 days, so that you don't want to run it, in a kind of, you don't want to run the arbitration first and then the Section 13A. I think it has to run concurrently so that you're managing time as well. Also, I think, how do we engage arbitrators to understand 13A? I mean, some of them maybe do, but I think a lot of those independent arbitrators might not understand 13A. So I think it's getting them to understand 13A so that they're making decisions based on what the requirements of 13A are. So I think that's probably something we could look at. And also the designated agents that bargaining councils have that go out and talk to employers. They are like the so-called enforcement agents. They do investigations, etc. as well, obviously. They need to understand 13A. I know in a lot of environments, they're trying to expose them to 13A, but I think that's important that they understand 13A as well, because it's just not another fund. It's not just not an holiday or leave pay fund, etc. They need to understand 13A, and it has to be dealt with in a very specific way. Right, so I think that's probably something that we could look at as well. So my last solution, proposed solution is we probably could create a working group. I'm not into creating bureaucracy and sitting forever on this thing. It must be a working group where focused towards coming with solutions. I think that's important. I know there's a wide divergences in terms of various funds about timelines and when things get done, etc., etc. But I think it's important to bring together the traditional bargaining council processes and the conduct standard processes. So I think the point I've made already, and have a kind of maybe an overview, a kind of broad guideline as to how we pull all of that together. That's the first point I think maybe that working group could look at. The second one is, second part of the mandate, which I thought is, what are the parameters to how to deal with companies that are in real economic trouble? All right. So I think that's something, because I think we must consciously incorporate that into the way we deal with things. That's the second part. And the third part is communicating directly with members. I think in this context, where in many cases, 80% of your employers, probably 80, it varies from fund to fund, 80% are small employers. One needs to think about, how do we communicate directly with members? For example, if someone who's not paying across, who's collecting contributions and not paying across, an employer, he's not going to talk to his employees about that, obviously. So it's a question of how do we communicate, and let's try and be innovative in the way we can. I know it's a problem across retirement fund entities, but I think more and more regulation is giving us, empowering us to do that. But let's find solutions there. And I've also, my last point is, I've also chatted to the National Association of Bargaining Councils. This is a body for where the various bargaining councils come together, and they were very keen to engage on the issue. Time was was very limited. So what I've suggested is that we can continue the engagement early in the new year, and clearly we need to involve Takalani and team in that as well, so that it becomes a process where we could bring in other entities that also need to come on board as well. So I would suggest we do that as well, and I would willing to offer my services if it's needed in that context. All right, I think I'll stop there. I don't know if there are any questions or any. And then thank you for the opportunity. It's really been great.
Oh, thank you so much, Mr. Govenden. I see there is a question from, or a hand from Omar Kiri.
Yes.
Giabeto, perhaps you could unmute Omar, and this time he'll be able to, let's see that he's able to actually ask his question.
Hello, good morning.
Good morning, Omar.
Yeah, thank you. Okay, I don't want to go too long into this dispute and issues. My only view is that the employers don't have to take the money of workers or steal. I don't use the hard word, steal the money of workers, right? Don't have to do that. There's many in the bargaining council for them to be able to address their concerns. There's short time, there's layoffs. If a company is struggling and can't have orders, they put the workers on short time. If they have serious problems, there's layoffs. there's various other areas, things that they can do to avoid themselves from stealing. They're committing a crime, and you're justifying this crime, and that's my problem. My problem is, how do you justify somebody stealing from somebody else? And then it comes to our attention as a fund that the employee is not paying. We are phone them, we ask them, guys, can you make arrangement to pay? No, they don't do that. We refer them back to the bargaining council. The bargaining council go to them and say, can you make arrangements for you to pay? They refuse. They go to the CCMA, whatever forum you have there. They refuse. We hand them over to the lawyers. The lawyers said, yes, ask them, can you make arrangements to pay before we go after them? So my question to you is, how much more must we do when an employer has taken workers' money illegally? And then the FSA comes to me and tells me I must take my customer fairly. I must go collect the money of those members. And you say, no, don't treat your customer fairly. Treat the employer fairly who stole the money. So I'm a bit confused. What must I do?
Okay, Takalani, you want me to respond?
Yes.
Yeah, I think, Omar, it's a challenging one. And I think, we agree with your sentiments, no doubt. I don't think anyone would disagree with your sentiments. But it's a question of the real world out there. And we're going to have to manage all of that within the context of laws and rights and all of that. Okay. And also within the commercial environment. So, you've got the commercial environment and its kinds of dynamics. And then you've got, the FSCA, and obviously it's trying really hard to create a framework that empowers trustees to actually do the right thing in terms of, getting employers to pay, getting members to pay, and so on. So I think, those are challenges, Omar, and you know what, we're going to have to find ways, clever and smart ways of doing these things properly. And, and the trustees need to come together and engage in terms of the best way forward. Thank you.
Thank you, Mr. Govenden. And I think that I share your sentiments. I don't think anyone that is here at this webinar or taking on the challenge of being a trustee is just, sort of saying we want to find ways to justify, not doing what is required. I think there are practical challenges. And as I said before, after Advocate Khumalo's presentation, is that we do need to create a conducive environment for you to be able to do your job a lot easier. And I think it's just, being able to share on this platform is important. The next question is from Mr. Danny Harting. If you could unmute, and perhaps it's just a comment, let's see. And then we can take our tea break for the day.
Danny, I have allowed your mic. Please unmute on your side.
Got it. There we go. All right. So thank you, Takalani. I think from the 3 webinars that we've had, it's clear that there are real challenges at bargaining council levels. And even when I engage with officials at the FSCA, it's clear that not everyone understands the challenges at the bargaining councils. I'm the PO at the Building Industry Bargaining Council, and I would suggest that we come back the new year and we arrange in-person meeting with the FSCA and some of the bargaining councils, and we just sit there for a day and we look at all these challenges, and the bargaining councils will then lead the FSCA on what do we need and what do we need from the FSA to help us getting our members' money from employers. So just to summarize, I think we should not leave everything here. We should definitely have some type of forum where we can meet up with the POs of bargaining councils, industry funds, or the pension provident funds, and just have a look and see what the real issues are. Thank you.
Can I come in there, Lani? Dani, absolutely. I think, that engagement is important because I think it's unpacking this environment. And, yes, there's diversity, but it's understanding that environment and the complexities within that environment. But like I suggested, it might be good to have a small working group that does a bit of groundwork before we meet. Otherwise we meet and we go through a whole lot of stuff. But
Yeah,
maybe
agree.
a few people before that, get together and actually exercise the minds and do some research. Can direct the discussion in a better way, I'd suggest.
Perfect. And Rama, if you need a hand, you can make contact with me. Thank you.
Okay, great. Maybe we must get volunteers, Takalani. I don't know how you want to play this.
Yes, I think we should see whether we can write to perhaps all the funds and just see whether we can try and put together how we'd like to see it play out. I think in our engagements, even with the funds in preparation, we had said, what we've wanted for the longest time is the bargaining councils to come forward and say, these are our challenges. And I'm glad that we've been able to give you the platform, because when you look at the Pension Funds Act and you look at just how you spoke about board of trustees and how you function in terms of collecting other contributions, clearly, there would be some misalignment with the Pension Funds Act. And I had always been tentative to say you bargaining councils are very unique, because I always felt like it was a way to say, no, we're not going to comply with the Pension Funds Act. But I think I'm slowly coming around to the fact that it is very, very unique environment. And we do need to understand it a lot better to make sure that we can create those directives or conduct standards specific. Remember, we're also trying to do fit for purpose. So you don't want to have the misalignment. Otherwise, it's not fit for you to be able to do what you need to do. So let's make sure that we can do that. And I know you offered it, and I had actually spoken to Gia to say we must make sure that we start arranging it. And thank you very much for offering to then also speak to the National Bargaining Council Forum for us to also then start that engagement. So thank you very much. Advocate Khumalo, I see your mic is unmuted. I don't know whether you wanted to make a comment.
No, I actually supported, the proposal that we should have a working group. If it was up to me, Takalani, I would give the FSCA and Treasury the power to blacklist all non-compliant employers so that they cannot get any business anywhere. And that would force them to either pay or stop operating.
Yeah, I know it works in some instances for your particular fund where they have to show compliance with the fund. I mean, in our
industry, there's a licensing mechanism that has been introduced where you cannot participate in a tender process unless you have a 13A letter for the fund. Yeah. But now, the fund trustees get threatened, and it's quite serious. So if it was done by the regulator or Treasury, and it was taken away from trustees, it would be much better.
No, I agree. And I think for the industry funds, we have contract cleaning after the break. So we'll also hear from them if they've had similar challenges and whether they were looking at doing something similar as your fund. We had catered for a 15-minute leg stretch, and I think we're all about ready to do that, just to get some fresh air, get some coffee, and then we'll be back to do 3 presentations for 2 more funds, and then we have a Q&A session. I'm inclined to still give the 15 minutes. So if we could be back perhaps at, let's say 20 past, just to round it off, and then we can start with the presentation. So we'll be slightly behind, but I think we've dealt with a lot of questions and might have a shorter Q&A session as well. And I think we almost just wrapped it up with a way forward as well, Rama. So I think we can definitely see to have a full sort of 18-minute break, and we'll see you at 20 past, everyone. Thank you so much.
Thank you.
I hope everyone's got their tea and had a good tea break. I'm going to introduce our next speaker so we can promptly start now with 20 past. Yes, the next speaker is Ms. Thamani Naidoo, and I call her Tammy, from the clothing industry, or Kwazulu Natal Clothing Industry Provident Fund. She has just taken over being the principal officer, I believe, and but she's had many years' experience in the clothing industry bargaining council space, and is also going to give us a presentation on their fund. I know she was quite nervous, but I just said to her she must just focus on talking about her fund. And because she knows a lot about her fund, she'll be just fine. So Tammy, I'm going to hand over to you to just give us your presentation as well. Thank you.
Thank you, Takalani, for that, or shall I say program director, for that wonderful introduction. Thank you to the FSCA for affording me the opportunity to give a little insight into our fund and the clothing industry as well. So if you could just bear with me, I'm just going to close my camera and start sharing. So just to dive into the contents, I will cover an overview of the clothing industry, the structure of our fund, the processes, which include our debt collection and our legal processes, the challenges that we experience, the opportunities that are available to our industry, and maybe touch
Tammy?
on. Hello.
Sorry, Tammy. On our side, we can't see your slides.
Okay, so just give me a second, Takalani.
Okay.
Takalani, can you see the visuals now?
Oh, definitely. It's beautiful visual too. Thank you.
Okay, apologies for that. Okay, so we'll just move on to the next slide, and thanks for alerting me to that. Okay, in terms of current updates on our industry, the South African clothing industry has been materially affected by the COVID-19 pandemic. Although lockdown restrictions and supply chain disruptions dealt a massive blow to the companies across the industry value chain, the closure of borders prompted companies to reduce their reliance on imported goods and increase local sourcing. In terms of recently implemented industry master plan, major retailers have committed to increasing locally made clothing ranges in their stores from around 45 to 50%, currently to 65% by 2030. Structure of the industry, and I think this is very important especially for the FSA to have an understanding. There are very low barriers to entry into the clothing industry, as minimal capital outlay is required to operationalize. So just to give you an idea in terms of the differential, capital requirement to create one clothing sector job is around 5,000 rands. Capital requirement to create one manufacturing sector job, excluding the clothing sector, is 150,000. The industry is therefore currently comprised of primarily small to medium-sized companies. These companies are important for job creation and to boost the economy. I'll just cover a bit of the industry statistics. The table that you have in front of you depicts the breakdown according to company size, and you'll notice that the large companies form 7% of the sector, And the micro, small, and medium combined consist of 93% of the sector. There are currently 588 registered clothing companies nationally, employing approximately 50,000 workers. The gender ratio is approximately 80-20 female to male workers. Structure of the fund. The National Bargaining Council has 3 regional offices, the Cape, the KZN, and the Northern Chamber. Each regional chamber currently manages its own Provident fund. The balance of my presentation is based on the KZN Clothing Industry Provident Fund. The fund was registered on the 12th of May, 1961. In 2008, the fund was registered in terms of the Pension Funds Act. The fund was initially self-administered. The National Bargaining Council was registered as a Section 13B administrator in 2018, and I must add, after some nudging from the FSCA, the fund has since been administered by the NBC. I'm going to move into our processes, and forgive me if this sounds boring, but I think it's important for me to cover this adequately. Our contribution collection. The fund has an exemption to collect within 10 days after the month end. 85% of companies make regular payments and 15% are in default. In terms of the 85% companies that make regular payments, 82% of the companies pay within 10 days. The balance of the 18% pay before month end. The debtors department engaged with employers via email and telephone regarding the overdue amounts. If attempts to get payment continue to be unsuccessful, then the compliance department is engaged to assist. And they do this by visiting the factory and engaging. In terms of reporting, a list of companies that are outstanding 30 days and over is sent to the trade union. The employer is formally advised via letter of the overdue amounts. Letters addressed to each worker are hand-delivered by the agents to the company shop steward in the presence of the employer. At 90 days, the non-compliance is reported to the board, and the board is sent a debtors report monthly. Bargaining Council legal processes. The compliance order issued for debt outstanding for 60 days outstanding. Previously, the compliance order was issued at 90 days. If the employer complies, the process ends. If the employer does not comply, the conciliation process begins. If there's no resolution, arbitration follows. An employer is given an opportunity, even at the arbitration stage, to engage with the bargaining council to remedy the breach. So, and just bear in mind, at each stage, we do bring in that opportunity to further engage. As a last resort, we offer a payment plan. And I'd like to touch a little bit more on our payment plan. The payment plan is made into an order by consent, subject to certain conditions, and I'm going to list them. Number 1, the interest is charged on outstanding amounts and included in the payment plan. Number 2, the current monthly contributions are paid up to date, and in this way, the risk premiums are also kept up to date. Number 3, the installments of the payment plan are kept up to date. And number 4, the employer undertakes to pay any outstanding contribution for an employee who leaves, dies, or retires. Coming back to the presentation, if no agreement is reached, the commissioner can order payment within 14 days. A default order is granted if no appearance is made, and the CCMA certifies the award in terms of Section 143 of the Labour Relations Act. In terms of the writs process, the sheriff is instructed to attach movable goods, and this will remain in place until the employer pays. With regards to engagement of external legal services, the board may, at its discretion, authorize the use of external legal services where it deems it necessary. Challenges. So these challenges are probably unique to the clothing industry. Unregistered companies, we have a huge informal sector, companies that are not registered with the Bargaining Council and therefore the fund. Our next point is the business name change and creating new companies. Companies change the business name or close the existing companies and open a new company to evade the bargaining council compliance. Cooperatives, to evade compliance to the bargaining council, delinquent companies convert to cooperatives. Cooperatives are of the view that they are not obligated to register with the bargaining council. Business rescue and liquidation. Companies start up and after a short while go into business rescue and then file for liquidation. Writs of execution. Employers change the name to avoid the execution of writs. Employers claim goods do not belong to them in the form of an interpleader affidavit, and the waiting period for a court date is at least 6 months. The reporting challenges, this has been discussed ad nauseum. I'd just like to say that I'm encouraged to hear that the FSA has plans to engage with the SAPS and NPA on effective reporting process. I would also like to add the matter of jurisdiction in dealing with SAPS. For example, a bargaining council office based in Durban reporting an employer based in Newcastle at the Durban SAPS would be asked to report to the Newcastle SAPS. So this further compounds the reporting challenge. Opportunities, compliance certificates. The Bargaining Council issues compliance certificates to compliant companies, which is used to tender for work. Large compliant companies outsource work to smaller cut, make, and trim companies. The Bargaining Council places a requirement on compliant companies to outsource work to compliant CMT companies only, or run the risk of compliance certificates being withdrawn. Retail sector intervention. The parties to the Bargaining Council have been engaging with the retail sector, and one of the outcomes is that retailers would source from the Bargaining Council compliant companies. DTI funding process requirement now stipulates that the applicant must be Bargaining Council compliant, or companies that are not Bargaining Council compliant may qualify but should submit a signed agreement with the National Bargaining Council for a pathway to compliance. Successes. Collection levels have improved when compared to even pre-COVID levels due to the following factors. Intensified collaboration between the Debt Collection Department and the Compliance Department. The Debt Collection Department and the Compliance Department have always worked together on non-compliance. From last year, we have improved the processes by holding bi-monthly meetings and weekly email reports from the debtors to the compliance and vice versa. As mentioned previously, when the debtors department fail in the efforts, the agents visit the company. Increased communication between agents and the company. Face-to-face interaction with companies regarding outstanding contributions has resulted in improved collections, and where the company is experiencing financial difficulty, the Bargaining Council has a better understanding of the predicament that the company is in, and this assists in implementing a more effective debt collection approach. Successful early intervention lays the foundation for a better working relationship with companies, thus reducing the progression to a legal stage. Some closing remarks. Bargaining Council funds are unlike corporate funds, and I will echo the sentiments of Mr. Rama and the other POs. We are therefore very pleased to see that the FSCA has taken the time to acknowledge and understand how bargaining councils operate. These 13A workshops have been very informative and invaluable, and I would like to use this opportunity to thank the FSCA for the time and effort that they've put into these sessions. Thank you.
Thank you so much, Tammy. I must also say thank you so much. From the time that we started planning this, that the principal officers that we engaged with, you were open and honest, and I must say at times it felt like, okay, how much more must the FSCA learn? But we had said to you, be frank and honest, and you definitely were. And I'm really glad that you were able to make the time to do the presentation for us. And I must say, I'm glad you brought in some color. It was actually nice to see some pink. It was different. So are there any questions for Tammy, or can we move to the next presentation? I see Mr. Ian Richards has said this is the second time there is a mention or the mention is made of payment of contribution within 10 days and not 7. Is this a special allowance? It's not to say a special allowance, but for those funds that have approached us and said because of the fact that they might need more time to distribute the monies to the different funds that they administer, whether it's a holiday fund or a sick pay fund or whatever else. They asked or were granted an exemption from the 7-day period, and so do have more time outside of the 7 days. So you do need to approach us, and then there would be sort of I want to say an alignment between what is perhaps in your collective agreement and what is practically possible, and then the fund would propose a time period, and then we'd work around that. Kia, I see your hand is up.
Thanks. Thank you, Takalani. I just have a question for Tammy. So on the one of the remedial options or actions made available by the bargaining council to employers that don't pay over the contributions was a payment plan, right, Tammy? And I just want to get clarity over whether these payment plans, so are they the various payments, are they paid over to the fund as one bulk payment, or are they paid over as and when the council receives these payments from the employer, they are paid over to the various funds? That made sense.
Thank you, Kia. So I can go ahead.
Yes. Please.
Okay. So yes, so the payment plans actually spread over a period of time. So for example, you could have a 6-month payment plan or an 8-month payment plan, and the arrears are spread over that period of time. And as I've mentioned, while you're paying your arrears, so you'd pay your arrears monthly, and in addition to your arrears, you'd pay your monthly contributions.
Yeah.
Does that answer the question?
Yeah, does that answer the question for you?
I think it does. I think it does.
All right. Tammy, there's another question for you in the chat that says small clothing companies used to disappear overnight only to relocate elsewhere. Is this still the case?
Yes, definitely, Takalani. That is something that we're grappling with as an industry.
Okay, no, and what are some of the, I don't know, I'm just adding to the question now, but what are some of the measures that you have in place to sort of see that, is it an ID number for the, the directors or something that you keep so that you can see whether it's the same company that comes up?
So, so what we've done, and I think, I think I speak for all the regions, is that we do regular inspections. I know the Minister of Labour has recently done an inspection in Newcastle, and they found many unregistered companies. We are aware of them, and we've taken steps. We've inspected, we've going the legal route, we've engaged attorneys. And I think it's predominantly, we have cooperatives, companies that do not want to register at the bargaining council. I have mentioned that the cooperatives are of the view that they do not have to register with the bargaining council. So we have legal proceedings currently in place trying to get these cooperatives on board, but it is ongoing. It's a challenge.
I see there's the hand up from Carmen Jefter. Perhaps you can unmute Carmen.
Good morning, everybody.
Morning.
And thank you for the opportunity. I am a colleague of Tammy's. So I just wanted to add to the earlier question and maybe shed a little bit of light on the current question. In terms of the earlier question, I would like to just differentiate the fund from other levies that we collect and subscriptions. So the fund, in terms of our payment plans, has a separate payment plan with its own bank account details. And the subscriptions and other levies goes into the council account. And as Tammy rightly pointed out, depending on the period of the repayment plan. So what we've tried to do from a compliance point of view is to avoid an overlapping of the funds from the council's main account to the fund account. In that way, tracking the payment plan is much easier and precise. So I just wanted to add that little comment on to the earlier question of how do we separate and how do we allocate the payment plans in that regard. On the current question, yes, I think Tammy did mention in her presentation that because the startup costs for the clothing industry is low, and moving one's few sewing machines is very quick to do. So that's basically all you need to do. The challenge of CMTs disappearing overnight is real. It is a continuous challenge that we've had over the years, but I think we are in the process of addressing those challenges, but it's not something that is going to disappear in the near future. And I'm pretty sure there are other industries also that have challenges with smaller companies who are continuously moving around and setting up shop in different spaces. So yeah, I think, ma'am, that is my little contribution, and well done, Tammy. You've made us proud. Thank you. Back to you, Chair.
Thank you so much, Carmen. I don't think there's or perhaps it's just your hand that's left, Carmen, as an old hand now. But yes, thank you very, very much, Tammy. I think you provided us with, again, some information that we might not have been aware of. And I think a very unique challenge in the sense that you've also got these really small employers that are more agile in terms of moving around and I want to say being able to evade compliance. But I'm glad to hear that there are measures in place that from a compliance, from a bargaining council point of view, there is something that is being done there as well. Our last fund is the contract cleaning Provident Fund, or the National Contract Cleaning Provident Fund, and they are a sectoral determination fund. And so we would refer to them almost as an industry fund. They are similar to bargaining councils. It's just that theirs is more, it's a sectoral determination and not a collective agreement, but it's on the same basis. It's for people in the, or specific grades within the contract cleaning industry. And we are joined by Ms. Carla Schoeman and Mr. Harish Soomar. From NBC fund administrators for them to do a presentation for us there. Thank you very much for making the time. Otherwise, we might not have had a sectoral determination fund, which would have been a pity. But I'm very glad that you accepted our invitation and also were able to represent the funds at this forum to share your challenges and opportunities as well. I will hand over to Carla. I'm not sure whether it's Carla who's going to start or Mr. Soomar. Okay, I think they have joined. I will hand over to you. Thank you so much. Sorry, your sound is still Yeah, your sound is not on yet.
Can you hear me now?
Yes, loud and clear. Thank you so much.
You'd think after all this time of COVID, we'd understand these things. But
no,
thank you so much. Sorry, were you saying something?
No, I'm saying I'm going to hand over to you. Thank you.
Okay. Thank you so much again. I was just saying earlier, yeah, after so much time, you'd think this technology would grasp it well. But thank you again for the opportunity to present. As you're saying, we are the sort of unique one as the sectorial determined fund. I'm here as NBC. We are representing the fund. So we have two groups. We have people that are going to present, and we have a support structure. I heard you earlier, Takalani, saying, you know, the department is behind you and they're there to support. We have the same sentiment in that regard. So I'm quickly just going to introduce everyone. On this side is the fund valuator. He's also the division head, and he's the fund valuator of CCNPF. And I have as well Mr. Adv Lambada, who is the head in the funding and fund accounting services division. And I have the presenters on this side, which is Mr. Leap Van Sale, and he is the executive head for legal services. And we have Carla, who is the senior executive advisor. And we have Harish Soomar, who is the manager for the compliance team within the CCNPF fund. So obviously I'm calling it CCNPF as a short, but we all know it's the Contract Cleaning National Provident Fund. Thank you again, and I'm going to let the presenters then take forward. Thank you.
Good morning, everybody. I'm going to be presenting the presentation. So I'm going to be disabling the camera so that we can seamlessly go through this. And which one is it? Sonia. This is an Type B umbrella fund designed by the Sectoral Determination for Contract Cleaning. It's also a fund that consists of a board of trustees that includes employer trustees and union member representative trustees. As we mentioned, it is a sectoral determination fund. This fund is unique in the sense that a legal subcommittee has been established to deal with non-compliance on the fund. There is a dedicated or compliance team and legal advisors that deals with the non-compliant employers on the fund. When all of those, efforts have been exhausted, that's when the fund uses the fund attorneys. In terms of the structure of the fund and how we deal with non-compliance, I'm just going to mention some of the challenges that the fund is facing with regards to the non-compliance. Is that some employers are not registered with the fund at all, either because of awareness or due to genuine non-compliance. Registering with other funds without applying for exemptions. When employers do register with a fund and they stop paying contributions and start developing a non-compliance pattern. In other cases, the employers are deducting contributions, not paying it over, underpaying contributions, or paying according to incorrect rates. The non-submission of schedules, coupled by some certain employees being omitted from the contribution schedules. Failure to pay LPI. In some cases, the induplum seems to be a challenge in that some employers are not able to pay the high arrear contribution or the high late payment interest on that, coupled by the arrears. In terms of, as we all know, in terms of the penalties and the challenges and the consequences of non-compliance is that death, funeral claims cannot be honored when there's no premiums or contributions. Claims are partially paid, and that results in members, lodging complaints with the PFA, and frustrated members coming across through to the fund. The fund is then designed certain measures, coupled by legislation processes that we follow. That is sending out monthly reminders to employers, sending them the LPI bills. The employer's statuses are changed to that of being non-compliant. Cases are being dealt with by the unique compliance team, in that we start scheduling meetings with those employers, asking them to address the arrear contributions. We first try at least between 3 to 5 times to propose employers to entering settlement agreements. If all those efforts have been exhausted and the employers have still not come to the party, so to speak, the matters are then handed over to the fund's legal department to issue letters of demand. And also in that process, we still try to engage the employer or encourage them to enter into settlement agreements. That is just basically a repayment plan. We try to reduce it to a shortened period of time and not span it across a lengthy period. Also, just to ensure that the recovery of the monies is in a shorter space of time. If that also sees no success and results in terms of employers coming to the party with our legal team, those cases are then referred to the fund's legal subcommittee. And at that point, the proposal is that these employers be handed over to the fund's attorneys. Coupled by that and other consequences is that through the 90-day report, these matters are reported to the principal officer, the board of trustees, FSCA, SEPs. Coupled by that, we don't have a bargaining council in place. However, we have good relations with cleaning associations to assist us in this regard. Employers are reliant on the membership of cleaning associations, and when there is non-compliance, we report these matters to the cleaning associations, who then assists us to engage these employers and remind them that if they don't sort out their compliance with the fund, their membership may be suspended or their audits may not take place. So that is one of the successes that we are having with the fund. In terms of our other successes, we've also designed welcome packs and guides to new employers and existing employers that talks through the processes of being compliant. Also, we identify certain employers that are making the non-compliance radar. We schedule employee training with them and talking them through, because sometimes sending them a pack doesn't necessarily mean that they're going to be compliant. Sometimes it requires us to call a meeting, call the employee in, sit with them, even if it means us teaching them how to use Excel. We go down and we use that. Coupled by this, when employers in a position to enter into settlement agreements, settle their arrears, we offer them the opportunity of receiving compliance certificates from the fund. And that seems to be working in the sense that they want those certificates, because those are the certificates they need when they need to renew their contracts or when they want to go out and tender for new work. I think that is it in terms of our success cases and our strategy that is used. I will hand over back to Naidoo.
Thank you so much, Harish. So the next presenter is Leap, and he'll just introduce himself and we'll go to the next slide. Can you just take it to Leap's slide? Thank you.
Thank you very much. Our intention here today is not to focus too much on the challenges. I think the challenges is like a golden thread through all the presentations that we listened to so far today. and I think we don't need to repeat it. We do have 4 areas of opportunities that we want to highlight today, that we as NDC in conjunction with the CCNPF will focus on, and that we want to share with the rest of the delegates attending here today. So the first of these 4 points I titled A Labour Law Solution to a Pension Problem. And our submissions around this point will deal with Section 34, capital A of the Basic Conditions of Employment Act. Before I deal with that particular section of the Basic Conditions of Employment Act, please allow me just to take a few steps back to tell you where we're coming from and what the context of our proposal is. So all of us in the industry are well aware that there's an overlap between labour law and pension law. Pension law is actually the newest of the 2 fields, and it actually stems directly from the fact that we still speak of occupational funds. You are only a member of a fund by virtue of the fact that you are employed by a particular employer. Now that brings in pertinent overlaps between labour legislation and pension fund legislation that stem from the Bill of Rights. So Section 23 guarantees all citizens that they will not be subjected to unfair labour practices. And then from Section 26 onwards, the Constitution guarantees that every citizen will be given access to social security. Now, to give effect to these constitutional imperatives, we have different pieces of legislation. On the labour side, we have the Labour Relations Act and the Basic Conditions of Employment Act. And then on the social security side, you know, we see things like the Road Accident Fund, we see the Occupational Health and Diseases Act, we see the UIF, and then pertinently also the Pension Funds Act and the social security that pensions provide to members. Now, against that backdrop and accepting that there is an overlap between labour law and pension law, we want to propose that we look at it differently from a labour law perspective, and not only from a pension law perspective. I think we all in agreement that you know, the reason why we are having these engagements is because the pension fund legislation and its provisions are delivering suboptimal outcomes, specifically for industry funds that we administer. So I want to refer you to Section 34, capital A of the Basic Conditions of Employment Act. This section was inserted by Act 11 of 2002 into the Basic Conditions of Employment Act, and it uses very specific language. I'm referring you to subparagraphs 2 and 3 specifically. And what it says is that if the employer makes deductions from an employee's salary in respect of his or her contributions to a benefit fund, as it's called in that act, then it must be paid within 7 days. And then subsection 3 says, if a contribution by an employer that it is required to make, for instance, in terms of the rules of a fund, that is not deducted from the employee's salary, similarly, it must be paid over to the fund within 7 days. Now, the wording of these sections creates obligation. You know, it doesn't create a discretion. It is actually very firm in the sense that it creates an obligation to comply. But here's where it gets complicated. In Government Notice 1827, that was published on 24 December 2003, it was proclamated that Section 34A does not apply to employers who are bound by the provisions of the Pension Funds Act. And I'm going to conclude this part of our presentation by saying that, seeing that it's 20 years later, I think that it is time that we revisit making Section 34A applicable to all employers and employees, regardless of whether they sought under the Pension Funds Act or not. We believe that the Basic Conditions of Employment Act contains very useful tools that can be used to improve on industry fund participating employers' compliance with Section 13A, We believe that these measures are a bit more informal. You know, labor inspectors can visit the employer's place, can issue compliance orders, can issue fines, etc., that can make a meaningful contribution to an improvement on the payment of contributions. I do also submit that the reason why Section 34A was excluded from employers that are subject to the Pension Funds Act needs to be revisited. So the legislator didn't want to have two competing statutory provisions and uncertainty about jurisdiction. I think that, you know, through industry engagement, and as we sit here today, we represent an industry, and we can cooperate with the FSCA and engage perhaps the Department of Labour that it is time to revisit and repeal Government Notice 1827. So that's our first proposal. Our second proposal's heading is the future regulatory environment. And here I'm referring specifically to COFI and the Financial Sector Regulation Act. We know that it's coming. We have been engaging with industry bodies and with the regulator, the FSCA specifically, and National Treasury, on fine-tuning the relevant provisions of COFI. The Financial Sector Regulation Act already came into effect, or some sections of it, on 1 April 2018. What is relevant for today's purposes, however, is that Section 290 of the Financial Sector Regulation Act, that is already in effect, changed the definition of institution in the Financial Institutions Protection of Funds Act 28 of 2001. Now, what is included in the new definition of institution is a participating employer in a pension fund, all right? The Financial Institutions Act sections 5 and 10 speak specifically about curatorship and then offences and penalties. And, you know, just to, you know, for the sake of brevity, what it means is that certain penalties and offences can be committed by an institution as defined in the Financial Institutions Act, which now includes a participating employer in a pension fund or a retirement fund, as we'll call it in the future. The problem is that Section 290 of the Financial Sector Regulation Act will only become effective by proclamation. So even though it has been promulgated officially, yet it has not been made effective. So we need this still to be proclamated by means of a government gazette. Now, what this means is in a future COFI/FSRA environment, it would mean that the Financial Sector Conduct Authority will have oversight over participating employers. And I do understand that I'm summarizing for purposes of time, but what it means is that the Financial Sector Conduct Authority will have oversight over participating employers when it comes to the payment of contributions. To conclude on this topic, I am of the opinion, and you know, I am open to criticism, but I respectfully do not believe that the FSCA is the appropriate authority to be having this statutory oversight over participating employers. What it does do that is very useful is it brings into play Chapter 7, Chapter 9, Chapter 10, and Chapter 13 of the Financial Sector Regulation Act. So by virtue of them being overseen by the FSCA, Chapter 7 provides mechanisms to issue regulatory instruments that can be applicable to participating employers. Chapter 9 provides for the FSCA engaging in info gathering, on-site inspections and investigations. Chapter 10 contains provisions dealing with enforcement, and Chapter 13 deals with administrative penalties. So in the not too distant future, we can expect these provisions to form part of our effective legislation, and time will tell, you know, how this influences participating employers' levels of compliance. The third issue we want to address is the issue of personal liability as envisaged by Section 13 capital A8 of the Pension Funds Act, and I'm going to hand over to Carla.
All right, thank you, Lip, and good afternoon, everyone. So in terms of this personal liability, I would specifically like to refer to, piercing the corporate veil. And we all are aware of the engineering industry's pension fund case that was recently handed down by the Western Cape. I think it was in June. So in that matter, the first respondent, which was the company, was in voluntary liquidation, and the second respondent was the sole member. And in these bargaining council funds, we do find these situations a lot where the employer falls in arrears, liquidates the company, and just starts a new company afresh. And then where the fund then proceeds with enforcement or recovery legal steps, there's no entity or no assets to attach. And or they must submit a claim through the liquidator, which is lengthy, and the chances of success are 0 to none. So in this matter, the second respondent was the sole member. He admitted the breach, but decided to hide behind the corporate veil. And the court found him personally liable still for the over 5 million arrear contributions in LPI. Then Wilana also earlier referred in her slides to a recent determination that was handed down by the OPFA, the Municipal Gratuity Fund. And in that determination, the adjudicator also held the two members or the two directors personally liable for the LPI as well as the arrear contributions. So it would be prudent for funds to, from the get-go, join the responsible people, either if it's lodging a claim with the PFA, whatever steps from the get-go. Don't let there be a time delay, and only upon realizing that there is not sufficient funds if the employer is in liquidation or there's no assets that we get to a warrant of execution stage. Yeah, that is for me in a nutshell. That's a suggestion that the chances of success might be slightly higher. Thank you, Lee.
Thank you, Carla. And then the last issue that we want to address today has to do with the in duplum rule. I know that it has been discussed in various presentations up to now. And we believe that we have slightly different views on how the same outcome can be achieved. Just before I hand over to Francis as the evaluator of the Contract Cleaning National Provident Fund, I just wanted to start with this remark, and that is that, and I know this may not be the popular opinion, that in duplum should preferably not be seen as a debt. We know that the common law rule of in duplum applies to debts specifically. We feel strongly that we should emphasize the fact that late payment interest is actually investment income. And therefore, we feel that placing a ceiling on a member's ability to earn investment growth may be problematic. Francis, do you have any thoughts on that?
Okay, thank you, Lib. I think from our side, really, when you look at the in duplum rule, it actually prejudices members because now, like Lib has indicated, the members are no longer going to be getting their full return should the outstanding amount be outstanding for a longer period and the LPI is very high. As soon as you keep that LPI, you are now exposing the members to a limited benefit when they retire. So we believe that at least on that part, it actually does prejudice members, and we should not be looking at that one. And also the view that we should not look at that amount as a debt, but as an investment which needs to be earning an investment income. And also, if you look at it from an employer side, if I'm non-compliant, once I have reached 2 times, there's no need for me to really worry about paying because the liability is not going to increase. So it actually encourages non-compliance if you look at it from the employer side, once the debt is becoming too high. So on our side, we just believe that maybe from the regulator, they actually need to look at it not necessarily as a debt, but to actually allow that liability to continue to grow so that members don't suffer. As soon as you keep it, you're actually penalizing members.
Yeah, thank you, Francis. So even though we said that, we do think that there are creative ways of getting around it respectfully. In our experience, the late payment interest rate that is being prescribed by the conduct standard and previously regulation 33 is substantially higher than the actual investment growth rate that the fund realizes. And I think one of the solutions that we can perhaps look at is to link the late payment interest rate to the actual growth rate having been realized in the fund. I think in the previous presentation by the Furniture Bargaining Council, reference was made to employers who are in genuine financial distress, and lands up in a hole that they cannot get out of. I don't think it's the industry's job to do them favors, but we do have to be creative in making available solutions that are more feasible and doesn't enrich the fund and potentially leads to job losses. I think then we missed the point. And then lastly, maybe we should look at the fiduciary duties of trustees. I do think that they're very onerous. Trustees do not have any negotiating space when it comes to signing settlement agreements with non-compliant employers. You are bound by statutory provisions, and for good reason. We just feel that, if we can legislate certain strict parameters within which a fund can negotiate with a non-compliant employee who's in genuine financial distress, it will take us a big leap forward in terms of making a difference to the challenges we're all facing. And that's it from us. We will take any questions if there are any.
Thank you.
Thank you so much for that presentation. Yeah, you brought up quite a few different angles there that we definitely need to look at, and I think one of them that already was mentioned is this collaboration between the Labour Department and ourselves, just to make sure that where we can, the legislations are seen to be supporting each other and not in conflict with each other, because I know that was one of the issues that definitely did arise initially, at least for the bargaining councils, but it did seem to be a little bit better at the moment. And I think the issue on the genuine financial distress, I think we need to just make sure that where we've got these large funds and communication with employers might be difficult, and communication with members might be difficult, we do really need to make sure that we give them the different options that might be available if they're in genuine financial stress. And I like Mr. Govenden's suggestion of, what do they need to give you to prove that they are genuinely in financial distress? Because I understand you don't want a stop-start environment. But just one question for now. I don't see any hands, but just one question from my side. How effective is, and you mentioned it a little bit, but how effective is the compliance letter at the moment for the fund?
Harish?
It's effective in the sense that employers are now realizing the urgency of it and the seriousness of it, because we're also mentioning to them that failure to comply, this is the ripple effect of what's going to happen in terms of all the steps that we're going to take to remedy non-compliance.
Okay, but
Takalani, just to add on to that, and we also highlight the employer's liability in a sense that if the member were to pass on, they will be liable for certain payments because premiums were obviously not received. And we also informed the employer that the beneficiaries, in a sense, will be informed of this because, it takes time to pursue the employers. And, beneficiaries come to our offices, they come to the fund, they come to the trustees to say, what's happening? What is this? So we try to keep all parties involved, also informed in the same letter per se, especially for non-compliance that's over 90 days, So if any of that is the situation, if any of the members were to pass on during that period of talking and trying to get the employer to come on board. Thank you.
Thank you. I think my I see there is a hand up, but I actually wanted to open it now because it is the question. And thank you so much again for the presentation. I don't know if Francois' question is for you, but I'll let him go first, and then I'll open the floor for any questions from anyone to anyone for us to try and just have a question and answer session for 10-15 minutes, and then we will close. Francois?
Thank you, ma'am. Yeah, look, I think from my side, and I'm speaking now with both hats on as a trade unionist and a trustee. If an employee of any company commits fraud at any company in South Africa, that person will be dealt with severely in a disciplinary inquiry, and he will be dismissed. Now we've got a law that says that you are committing fraud because you're deducting people's money off his salary, and you're not paying it over for whatever reason. And then sometimes it happens that the aggrieved people that stays behind because the main member of the fund has passed away must run around and get money because, look, and I'm not saying it is like this, but really this is actually like an insurance company. I pay a premium, I expect service. The member pays the pension fund and he expects a service. Now a person has not paid. Now the aggrieved people stay behind, but yet there's a law stating that if they do this, it's a criminal offense. And that is why we took the decision at MIPFA on that serious stance. Because if one of my members commits crime, let me use our fund as an example. I've got members at the MIPFA pension fund, and one of my members commit a crime. He's going to be dismissed within 7 days. And in this issue, we allow people to come back only after 90 days, tell us, oh, no, sorry, I can't pay. We give them a payment plan. 6 months later, he stops paying, and then still nothing happens. And then still that poor person that left his family behind could not get all their money because you can't pay a person what is not in his fund. And that is why I've got a very great concern with this issue. That, you know, we're sitting here and I hear what the people are saying. Yeah, but the FSCA must not deal with this and this guy must deal with this. You know, when we employed our service provider, he and I say that and he can testify to that with the greatest of respect to our legal people and to our SAPS. You should have seen the runaround we got when we started with this process. But this is not actually fraud. The NPA couldn't give them guidance how to do the work. Then he went to the courts, and the court says, but what must we do about it? So there was a law coming in place guiding this, and nothing on the ground has been done. And I just feel that with the greatest of respect, we are all contributing to a pension fund, and I do not want my employer, Solidarity, to take my money and use it for something else, and at the end of the day, if something happens to me, my wife or my kid has got no money, and so do all of us sitting on this platform. And it seems like that we are making too many plans, and there's too many escape gates for the employers to get away. Here we hear that people can get an extra 30-day exemption because they don't pay. Yo, I want to go and represent my members if he commits fraud at the Building Bargaining Council, and I say, okay, now give me a 30-day grace period. I will speak to my member to bring your money back. Really, for me, it's very difficult to do this, and that's why I say, please, I put it in there that I want to be part of this, because this is a serious headache for the industry. It's a serious headache for trade unions that need to represent their members on trustees, as trustees in the fund. You must remember, I sit on the board of trustees on the pension and provident fund of MIPFA. And we give our PO instructions, and if he doesn't follow it, we give him very hard time and tell him what, but why you didn't do it, because you're playing with the members' money. We must remember this is a third party's money that the fund is playing with, is doing his service with, and the employer is number one, where he's not paying the money over. And all of us is in a line to see that our members are there. The FSCA, they make quick rules to say, but if a trustee doesn't comply, he can also get serious consequences. And that is why all of us that are sitting here and principal officers, that there is huge insurance policies taken for trustees and principal officers, that if they take a wrong decision, they can go to court. But here now, it seems like, and I'm not saying it's only this workshop, we've picked it up along the line while we learned a lot of lessons, that the employers wants to make plans for people that commits crime. And we must have webinars like that like this. This is I tell you, this is very learnful for me. But I'm just saying, I think we're giving people too much leniency that commits a crime. And the poor guy on the shop floor that pays on a weekly or monthly basis is the guy that's going to stand with his hands in his hair to explain to his family why I don't get my pension. Or the pension fund must tell his wife, why can't they get the death benefit because the employer is behind? And that is very near to my heart for members to suffer consequences like that, for employees that, I mean, we sit with the same problem in the MEIBC. You go to the engineering company today, tomorrow it's gone, then you hear they opened up, if they closed down in Benoni, they opened up in Springs with another name. New employees, old employees sit on the street, they're all behind with their pension fund.
Yeah.
So it's a very sad thing. So I really request that if you guys do that, I want to form part of that committee, and we need to come up with something concrete and maybe more quicker to resolve the issue. Thank you for allowing me to vent a little bit. Thank you.
Not a problem, Fancha. I think, yeah, I don't think we ever want to see a situation where the scales are tipped more in the favor of an employer more than a member. You know, as it is in the Pension Funds Act, if a member is found guilty of fraud or misconduct, you know, there's even compensation for the employer in that regard. So I don't think anyone wants to see, you know, it being better off for an employer to institute action against a member than it is for a member to institute action against an employer. And I think I'm just going to end off with saying, yes, I think we need to find ways to handle this a lot faster and effectively, as I said before, because it really isn't, it wouldn't be ideal for us to end up in the trap where we say we've built very nice legislation that doesn't work, right? So I think we definitely need to make sure that we do not go down that road, and we make sure that we do something about it to the betterment of members and the system of retirement funds, that it is actually producing the right outcome. Kia, if you could unmute my MIDI.
I have allowed their mic. They can unmute on their side.
Hi, my MIDI, how are you?
I'm good. How are you?
I'm good. Please go ahead with your question.
Yes, thank you very much for very interesting discussions, very refreshing presentations that were made, and, you know, highlighting the challenges that we face with respect to Section 13A. And in some of the presentations, there were also solutions in terms of how these can be approached. But I just wanted to highlight one thing that I think is critical as we move on and you know, face this challenge. That I think it is very important to understand that always when we are reactive to any challenges that we have, we don't win, because obviously we keep following this or other problem that arises in a situation. But if we have a very structured process of managing the challenges that we have, or let me put it in this way, in this case, what we want to achieve is the Section 30A objectives. We want to make sure that collections are made. We want to show contributions are collected on time, that they reflect on the bank, that reconciliations are made, schedules are received, all of that. So we cannot achieve these without a very good process of risk management. Risk management is very crucial to be integrated in all of the things that we do as we manage this challenge that we are facing. Because you will see that all of the issues that we are bringing in, maybe at ad hoc or haphazard level, risk management forces you to have an integrated approach of how to deal with this issue and what are the processes that we need to follow. And you are able to monitor the progress that you are making as you move along. It was also to me very interesting to hear I think somebody speaking on behalf of the FSCA saying, yeah, we are having these determinations, but we don't know which ones are honored, which ones are not, because we don't have enforcement powers. Right there, you just see a gap that this process is very important. I think somebody, Francois, said something about how this serious headache and serious challenge that is in the industry. So I think if all of us just look at our processes and how to do it, because once you have identified the problem and you are making determinations, even if you don't have powers to enforce them, it would be good actually to just give us the stats of what the impact of this thing that we are facing, what it is, how many determinations we've issued in this respect, because risk management also helps you to look at your risk indicators and to be able to see, for instance, the trends and the impact that you prioritize the impact in certain funds, like we see now in this case, that in the case of bargaining industries, how the challenge is maybe more pronounced than in other areas. So it helps because then you get to understand the industry, and when you identify your risk and sort of those things, you are able to upfront have a plan that I think will definitely help us to see a reduction in the problem that we have, or to be able to see the steps that we are taking, and which ones are successful, which ones are not, and look at how then we bring new challenges, and also to be monitoring even whatever is emerging in the different areas that we see. So yeah, I think we started a very good conversation, but I think we need to also, as we go along, integrate very good risk and compliance strategies in this, what we're doing, so that we can actually be able to together to see the challenges, especially because even as pension funds were different in where the industries we're operating in, or yeah, the situations that face us in different scenarios. So yeah, I really appreciate this. And yeah, I'm also prepared to take a part as we move along, just helping us to develop mechanisms of how we can deal with this issue. Thank you very much.
Thank you very much, my media. I think I'm not going to say I'm defending the PFA or the OPFA, but they would have given you that response was really what is legally the case. But they do and have tried to find ways to make sure that the determinations are issued, even from our side. As Naheem said, or I think it was Wilana that indicated that they will let us know where there are funds that they see either are not cooperating or are not even instituting or going forward with the determinations. And, they've sought solutions to try and see how can they even assist members, because it's costly for members to go to court. to further the matter. So I think they gave you a very, they gave you the legal response, but in reality, because they care so much, right, Wilana, they actually are trying to find other solutions to assist members to make sure that that determination actually means something and it is carried out. Rama?
Okay, thanks, Madam Chair. Yeah, I think, Francois, I think has raised some very cogent points, and I think, it bears taking up at some point. I think, in the medium to longer term, I agree with Francois, where maybe we need to reframe those issues or those offenses in terms of non-payment of contributions or late payment and so on. I think we got to reframe that, but that's going to take more time in terms of looking at how we reframe and how can we fast track. But in the meantime, like the last speaker said, I think there's a lot of opportunity to optimize, the instruments we have at the moment. I don't think we've optimized, for example, the legislative instruments we have. We haven't optimized, I think, maybe processes, how we deploy legal, how we deploy communications and so on. And I think maybe this engagement that we're talking about, Takalani, with FSCA and the funds, I think if we can optimize a lot of that, and let's see how far, I think we can be much more successful than maybe we've been in the past. Thank you.
Takalani, I think you're on mute.
Oh, sorry about that. Yes, thank you very much, Rama, for those comments. I don't know, Kia, if there's anything you wanted to comment on Rama's comment.
Nope, there's nothing from my side.
Wonderful. Then we can go to Albertina Lefatla. Thank you.
Albertina, you have muted yourself.
Oh, okay, I'm sorry. Good day, everyone. I don't know if I'm out of order. I'm still on the learning curve, so please beware with me. I just want to check about the moving of the employers that are changed, that are closing down the companies and open maybe in their houses, they open in garage and so ever, or move from some places to another places and not pay they're not contributing anything to the Provident Fund or retirement fund or everything. I just want to check maybe how this can be resolved, how this issue can be resolved so quickly that the employers mustn't take that advantage of doing that, because end of the day, as a worker, we got a problems of those employers that are moving, that are closing down during the weekend time and then run away. And then the second thing about the late contribution is also giving us a problem for those employers that are late contributing the workers' money, because when the member is taking a retirement fund, is whereby that worker can get their monies earlier because of the employer didn't contribute the money as that employer, that certain company is on arrears. So my question, I just want to know how we can solve this problem so fast that the employer mustn't take that advantage of doing that. Thank you very much.
Thank you so much, Albertina. And I think all of us, I actually feel like I'm also just still learning now after all of these webinars. Every now and then you always get information that you didn't know of. But I think that's probably the main your main question relates to exactly what we're trying to resolve here. And I'm wondering whether on the fund that you represent, what are some of the measures that you have in place for now, and how we can see what needs to be sort of augmented on that for it to be effective. But I think it is something that is definitely troubling a lot of funds in terms of how to make sure that we can do this a lot faster. So I might actually not have an answer for you, Kia. I don't know if you have a comment, or anybody else from the floor might want to assist with that. Yes.
From my side, Taki, you know, on her, I don't necessarily have a response right now to her main point that she raised, but I think, and this could have been something that was also raised in the previous webinar, that I think we need to get maybe have a better relationship with the CIPC in terms of registration of these companies and so forth. You know, that's an avenue that definitely can be explored, or other stakeholders, role players in this whole ecosystem that can be identified, and we forge a relationship, you know, with any of the other stakeholders that would be able to assist.
Yeah, I definitely think that's something we need to look at, even with in the previous webinar where we spoke about validating employers and seeing if there could be a system in place to make sure that we do verify information in some form or fashion, so that we can find them where they are. I think there's a hand from contract cleaning side, but you can unmute.
Okay, good afternoon, everyone. It's Francis Magidi from NBC on the contract cleaning side. We have discussed the issue of non-compliance quite a lot, and also the burden it places on the various funds. I think the challenge that we actually have is that we are trying as different funds to come up with solutions and trying to get employers to be compliant. But if that responsibility is transferred back to the FSCA, and then the FSCA can charge maybe a small amount of levy across all funds, and then they get maybe the lawyers to actually do the compliance across the whole country, it might actually be more cheaper and more beneficial to all the funds as well as to the members whom we are trying to help. Thank you.
Yeah, I think from our side, one of the solutions, not I think, but one of the solutions that we're trying to look at as well is how we can set up, you know, training even in the magistrate's court. I know Advocate Khumalo also mentioned how difficult it can become. And it's one of the avenues that we need to look at in this whole chain, from the police to the prosecutors to when it ends up eventually in front of, you know, in a court for us to deal with. I don't know if it would, you know, necessarily ever end up back at the FSCA. You would recall that we did have an enforcement committee before, and unfortunately we encountered problems there where we couldn't action most of the settlements because some of the records of the funds weren't, even the test cases that we took weren't ideal for us to go after the employers. I think we do need to make sure that the system is working properly. From the time that employers contribute, funds need to pick up quickly. That, you know, contributions didn't come in for a member. It's no use waiting until 6 months down the line, you know, then to say, oh goodness, we didn't have a contribution for this person. And if it works efficiently, then we can definitely look at all of those options for us to collaborate with other people. So it is something that we're looking at. But it might not necessarily fall under, you know, the FSCA taking control. It might just be rather that we are overseeing that all the other avenues that the fund has is actually working efficiently, whether in training, workshops, or anything like that, with other authorities to make sure that it actually works, so that when you go, you don't face the same problems that you have now. Donna McFarlane.
Donna, we have allowed your mic. Can you please unmute on your side?
Everyone, can you hear me?
Yes, we can.
Hi, everyone. My name is Donna McFarlane. I'm the attorney for the South African Road Passenger Bargaining Council Retirement Fund. In terms of getting employers to comply, we've, with many of them, hit an absolute brick wall, where the point that we're now having to revert to is claiming personal liability from the owners of the companies. Now, I know you have to go to the High Court to enforce that process, and it takes a while and it costs lots of money. So I was wondering, is there any way that it could be introduced that the PFA somehow has the ability to impose personal liability against the owners of the companies?
So I'm not sure if, sorry, I'm not sure whether Wilana is still on the line.
Hi, Takalani, I'm here.
Oh, hi.
What's the question?
Donna, would you like to repeat the question?
Yeah, sorry. So when we hit brick walls with companies and we cannot get anything out of them, we've taken them through compliance orders, we've tried to obtain their assets, we end up that their assets are owned by different individuals, and we reach the point where we now need to go after the owners in their individual capacity. Taking it to the High Court is quite an onerous and drawn-out process. It takes quite a while, and it gives the employers an opportunity to get shifty and find ways around it and disappear, etc., etc. Is there any way that there's an expedited way of getting the PFA to hold the owners of companies personally liable? Or perhaps my question is, does that exist already, number one? And number two, is it a potential that we can look at incorporating?
Okay. In that aspect, we can only issue an order, issue a determination, like the example we had in our second case of the municipality and the gratuity, municipal gratuity fund that took them to us. And we also said that the persons that is financially involved in the manager's finances can be held equally liable, jointly liable, and possibly personally as well. So in some instances where the funds comes to us to ask for a determination against a non-compliant employer, it will be against the company plus any of its directors and people that's in charge of this company's financials, so that when we do issue an order and the fund then needs to take it to court for further execution of this, then I think, like Carla also mentioned, from the start, you have the employer and you have the people that can be held separately and jointly liable for the arrear contributions or the amount that you are trying to claim from. But we won't be able to enforce because our functions stops when we have issued the determination.
Okay, yeah, Donna, PFA does have those powers.
Sorry?
What did you say?
Sorry. So I said that's good to know that the PFA actually does have those powers. So it's not necessary to go to the High Court for that purpose, unless you get to the point of enforcement.
Yes, because in our determination, we will say the order is against the employer plus whoever is together with this company responsible for the financials.
Yeah, Donna, if I could just add to that as well, I think, unfortunately, and why I mentioned earlier that, you know, we must also seek ways to make sure that the prosecuting authorities or regulatory bodies that we can engage with that are responsible for some of these things. You know, when Wilana mentioned function, from my side, I would say jurisdiction. You know, there are certain things that are not within the FSCA's jurisdiction. So for instance, if we have said, and it is a statutory or criminal case, we don't prosecute criminal cases. So there's actually nothing that, you know, we can do in that instance. But can we find ways to make sure that when you do need to open a case, that happens in a smooth, efficient, cost-effective, you know, all of those things to benefit the members. And I think that's where we, you know, and I know the comment also that came from NBC now again is, can the FSCA, you know, take this over? I think we're always going to have, we can't do everything, you know, the same as what the PFA has got. It's not designed that manner. There are different people that are responsible for different laws in the country, and unfortunately, our jurisdiction is limited. And so we just need to see how we can make the whole system work better.
Appreciate it. Thank you, both of you.
Thank you. I don't think there's any other hands, Kia, unless I'm not seeing well. I think it was just Donna's hand in the end now. Otherwise, I think we've come to a close at exactly 12:45. So I want to say yes.